Okay, for those of you who just came in, this is something that we can prep for and to orientate everybody to roughly the intent for this session. So there are possibly two ways that we can go with this session. The first premise over here is to help all of you to get your own wills done, right? So if you've already done your wills, then great. Maybe there's something new that you can want to consider after today's session. But for the rest of you who have not done your wills as an ESP, then this session is to help you get your wills done, right? In a group session like that, we'll go through what are the planning considerations to have, and the main purpose of this is if you haven't done the planning for yourself, right? And many of you could be because you're not quite sure what needs to be done after 5 full days of training 6 months ago. Now it's a vague memory of what you're supposed to do for your plans. Right, so this session is trying to give you a refresher for that because it's quite critical for you to think about your own estate plans. Simply because it is you're in the best position to do your own plans, right? And if you can't draft your own will still after all that, it's going to be pretty hard for you to do the same thing for your client, right? Simply because you are the one that know what stuff you have. And so for those of you who just came in just now, take this time at the back of that handout that you have, the wills planning worksheet, the back of it, to start thinking, listing down what stuff you have, right? At the bottom, there's some space on the last page. So start writing down what are the assets that you have, your insurance, your houses, your investments, your cash in your bank accounts, your cryptocurrencies or whatever else you have. List those things down very quickly, at least in broad categories, if not the individual items, at least the broad categories of assets that you have, right? So it's important for you to have that in mind. Okay, and then beside that, on a separate area, you want to list down who are your potential beneficiaries. Again, it's just for you to think through who are your family members that you care about, that you probably want to provide for at the end. When in your wills, these are the people that you want to maybe visualize and think about giving to. So you can, it helps you a little bit when you get to the how do I want to distribute my stuff part of the session today. Okay. So I think we're going to start pretty soon. So if you can spend some time doing that, writing down your asset list, writing down who are your beneficiaries, that's something that you want to get done. And in terms of process, right, this is a process that you probably want to do as well, right, which is before you meet up with a client to get their wills done, you should get this piece of information from them, these two pieces of information, what assets they have, who are their potential beneficiaries, right? Because if you meet up with a client and they haven't gone through that, it's not that they don't know the stuff, right? They just don't have a very detailed listing of these items. They haven't done some of their homework. For example, when it comes to insurance, right? They may say, yeah, I have some insurance. What are they? I think I've got some term plans. Which company is it with? Don't know. How much is it? Don't remember. Any nominations? I'm not so sure. And then your whole session with the client is wasted, right? So it's quite important to prep before the meeting. And so one of the things that we could potentially cover, right, depending on how fast the first part of the session goes, would be to go into what do you do in that first meeting with the client, right? So we may switch to that. That was the original plan, but we switched gears a little bit halfway. So now we're focusing on helping all you here as ESPs to get your own wills done first. At least review it. If you've already done your will, then maybe review it again in light of some of the things we'll be discussing today. If you have questions that your client raised about objections and stuff, feel free to bring that up as well, and we'll try to address it as we go along, right? So again, this session is about helping all of you to get your own wills done because you need to guide your clients through that same process, right? So I guess with that, Annabelle, can we go ahead? Yeah. Right, so let's jump to today's session. So it's called Wills Made Effective, and the key operative word here I'm trying to focus on is effective wills, right? This is as opposed to what many clients think about in terms of drafting estate plans. I just do a simple will enough, 50 to spouse, 25 to son, 25 to daughter, right? Those of you who have attended my class before know that famous phrase from me, right? 50 to spouse, 25 to son, 25 to daughter. We want to, that could be a valid will, but a valid will may not be enough, right? So we want to make an effective will, and I'll explain what we mean by effective will, and that should be something at the back of our minds when we're helping our clients draft their will. Okay. So the key objective we have for today's session is really just to learn how to draft an effective will. Right? There was actually quite a lot of things that I had originally, but given the time, I decided to streamline it and maybe focus on this a bit more. And if we end off this session early, then as I said, we could switch gears to talk about a couple of other things like maybe first conversations, right? What do we have? I call that the art and science of estate planning conversations. So with that, let's just jump into drafting an effective will. So what do we mean by an effective will? Okay, so the first concept we talk about is having sufficient redundancy. All right, so when we think about wills, there must be sufficient redundancy. A lot of times when people draft their wills, they just say, oh, when I die, I want my spouse to be executor. That's it, right? And that causes potential problems because there's insufficient redundancies, which means that in a case of a common disaster, your client, the testator, together with the spouse, passes away in a common disaster because they sat in the same taxi or went for the same holiday, aeroplane crash, and both of them died together. And when there's insufficient backup in terms of these appointment holders, you end up with LAWA, right? Letters of administration with will annex, and the client ends up subjected to getting sureties in place to complete the whole process because now the appointed executors are not there anymore, unable or unwilling to act, right? So one part of the planning is we need to plan for sufficient redundancy, right? Redundancies in terms of the appointment holders, but also redundancy in terms of the beneficiaries, right? Again, back to the example I gave, simple will, the client may simply be thinking about my main beneficiaries are my spouse and kids, and so I just name them in my will in my residuary clause, right? But again, common disaster happens, they don't think about it, and the estate planner doesn't prompt them to think about it. As a result, they don't have anybody else named in the will, and in a case of a common disaster, the rest of the estate gets distributed according to intestacy laws, which is again far from ideal, right? The client has spent money drafting the will, but still end up distributing via intestacy. So that's what I mean by an effective will, right? We need to think about making sure the will deals with certain contingencies that we can plan for. And one of them is this common disaster, right? So we also plan for contingencies, right? In a sense, we plan for common disasters. What happens in a common disaster? If you've got a jointly held property, do you think about the common disaster? Do you think about what happens when some of the beneficiaries predecease, right? Again, that's an example of effective will. If you recall, during the onboarding training, when we do the EWF, there's always that substitute column in your EWF, right? And you need to ask the client, right, if beneficiary A passes away, what do you want to do with beneficiaries A's share? Who do you want to give it to, right? And we talk the client through that. This is where, again, for many clients, if they try to DIY, do their own wills, this is where the problem happens, right? They don't know what they don't know. The whatever template that the lawyer gives to them doesn't adequately prompt them to think about these issues, and so they draft a very simple will, which doesn't take care of any contingencies, it doesn't plan for any redundancies, right? So as a result, when those things happen, and we have no control whether they do, I mean, of course, we don't expect to die in a common disaster, but if it happens, the will doesn't adequately deal with these situations, and that would be an example of an ineffective will, okay? The third and final part over here is how we handle assets appropriately, right? Again, for many people, the idea of a simple will is when I die, I just 50 to spouse, 25 to son, 25 to daughter, and I don't consider the individual assets. We never think about does giving my HDB flat equally to everybody make sense or not, right? And so we're going to see a little bit about how we plan for some of these problematic assets. And part of the estate planning process really is to go through that with the client, right? Again, from my past experience dealing with a lawyer, when the first will was done, a lawyer, $250 paid for by a Manulife agent. All I got was this piece of paper, and I literally fill in the blanks, right? Some of you may have experienced that yourself. The problem is, as a client, I don't know what I don't know. And so again, the will ends up very simple. They ask me to fill in what percentage I want to give, and I just fill it up, right? Never considering whether those assets, like investments, right? We will see that a little later. Does investments distributing 50 to spouse, 25 to son, 25 to daughter, does that make sense or not, right? Because if the kids are too young, they can't hold a CDP account, the spouse is not financially savvy, she doesn't know how to manage investments, then giving it to her does not make sense, right? So the job of the estate planner really is to identify these assets, which is why I asked you all to list down your assets first, right? We're going to as we go through some of them here, I'm not going to be able to cover every single one of them, but I'll be talking about some of the more common ones in this session. As we go through them, if your client has those assets, then you want to have that conversation with them, right? To get them to think about, okay, how else to distribute it, okay? And it's also probably an important thing to highlight over here is that when it comes to estate planning, right, every decision you make, there's always a set of pros and cons, right? The problem that most clients face is that they are very limited in terms of their scope, in terms of understanding what can or cannot be done, right? Again, for most people, their thinking is that if I die, my spouse is my executor because I trust my spouse. It's very one-dimensional to some extent, right? Very limited in terms of what they can do because that's all I know. I don't realize that I can consider other parties. I can think of substitutes. I can think about joint appointments. I can think about a corporate executor. These are not in their radar because they don't know it can be done, right? And I used to like to joke that because clients never die before, so they don't know what happens, right? Some may be a little bit more knowledgeable because they've experienced that with some relative passing away. But unless they are the ones actually handling some of the cases, again, it's very third party, a lot of half-truths, and that's where all the problems lie, right? Clients don't know what they don't know. And so as a result, the planning is very limited. So our value add as estate planners is that, firstly, we attend training, right, provided kindly by Precepts, like sessions like this. You broaden your mindsets to understand the solutions landscape, right? What are the possibilities? What are the potential problems? So that we can bring that experience, that training to the discussion with the clients. And that's really the key value add we have as estate planners, okay? So coming back to the idea of effective will, that's what I mean by effective will, right? We make sure that there's sufficient redundancies. We plan for substitutes, right? Substitute executors, substitute guardians, substitute beneficiaries. We think about contingencies. In the case of common disaster, in the case where some of the beneficiaries predeceased, we think about what else do we want to do, right? Rather than to leave it to some kind of default actions, right? Again, an example of that would be, if you recall this concept called doctrine of lapse we covered in class, right? Anybody remembers that? Or return to me already. Right, doctrine of lapse, right? That's where if I make a gift to a child and the child predeceases me, but leaves behind children of their own, the gift to them will lapse, right? So it's a default action, but only works for kids. So giving to, let's say, my sibling, for example, that doctrine of lapse doesn't apply, right? So when we think about these contingencies, we plan for if that sibling predeceases me, right? And chances are statistically that might happen because we are similar age group, then who else do I want to give to, right? Do I want to give to somebody else, or I'm going to route the asset back into the residuary estate to give to my residuary beneficiaries? It's about helping the clients to think through this and show them what are the possible options, right? And of course, the last part here again is dealing with the problematic assets, right? And at the heart of it, that's what we mean. That's what I mean by an effective will, right? We talk through this and we make very deliberate decisions on how to distribute stuff, okay? So that's the idea of that. Okay, so you'll have the will drafting checklist over here. So this is my simplified version. Precepts has kindly done up a very professional looking one. Okay, and so you can use that as you're going through each of the different sections, right? Your job will be to think about your own estate plans, right? About who you want to pick as your executors. If you have kids that are minor, who do you want to pick as children? Not pick as children. Who you want to pick as your guardians for your kids? Yeah. Right. And so think through that. Think through the stuff we're going to be discussing. What do you consider when you're making that? And as I'm sharing that with you, that's the same kind of conversations you're going to have with your client, right? So let's start off by talking about executors and trustees. Okay. So what we're trying to do in this session, when we're discussing with the client is, again, if you get any templates from the lawyers, it's going to be very straightforward. It's just a space over there and you just pick your executors, right? Again, many people end up picking very simple solutions. They just pick a spouse, they pick maybe a sibling because their decision criteria is very simple. I trust that party and I know that person and therefore I pick it, right? But there's actually more things to consider. The first of which is responsibilities. So you don't need to memorize this, but you can, I don't know, maybe have that as a reference or Google for it or something like that. I think I Googled somewhere and put something together, or maybe I use AI, I can't remember. Anyway, this slide here is to show you that there's actually a lot of things that the executor needs to do, right? And so thinking about whether the choice of your executor, like say your spouse, right? For many people, they still pick their spouse. Would their spouse be in the right position to do that? Right? Be able to play all these roles, to handle the legal aspects, to deal with the administrative nature of the job of the executor, to handle collecting of assets, tracking the asset, the inheritance, expenses that go out, handling other miscellaneous stuff like record keeping, right, to track what assets have gone in, what assets have gone out, what distributions have been made, attending court appearances, right, when required. Do they have the time, ability, and skill to handle all these things, right? So it's not just I trust that person, but there's actually a lot of leg work that needs to be done, right? And if you think about it from a spouse perspective, right, again, many people pick their spouse. So our job will be to kind of act like the devil's advocate to give them a different perspective, right? Which is, if you were to pass away, your spouse has literally lost his or her best friend, right? Would he or she be in the best position to play all these different things that need to be done, right? Would it be overwhelming, right? He or she might still have a full-time job to look after. If there's minor children in the estate, you still have to look after the children. The children are probably grieving. They may not totally understand that one of their parents has passed away. And so that surviving parent slash spouse will have to provide comfort to the children. On top of that, still have to look after the house and take care of all matters. And then you're going to burden him or her with all these administrative responsibilities of the executor. That is not easy, okay? But having said that, most clients still end up picking their spouse, okay? And that's not a wrong thing. At least minimally, what we've done is we've shared the critical roles, and in a sense, right now, it's an informed decision, right? Then the next part we want to consider, right, would be perhaps, as we mentioned, the contingency plan, the substitute, right? Other than spouse, who else do you want to consider? So that if the spouse is overwhelmed and unable to handle the responsibilities, you can consider somebody else to take over, okay? So in terms of criteria, I have actually different acronyms I use over different time, but today this acronym is called ACT, right? We want an executive to be able to act. Sometimes I call it CACT, and various times I give it different names, but today it's called ACT, right? We want the executive to be able to act, and it's spelled as ACCT, right? So how do I select the criteria? What do I need to think about when picking the executor? So the first one is available, right? In the ESP onboarding course, or at least the 3-day course, you learn that the executor role is heavy responsibility, right? A lot of things to do, meet up with different financial institutions, if you're engaging a lawyer, you still meet up with the lawyers. There may be court appearances that need to be done. So it takes up a lot of time administratively, and it takes the client, or rather the executor, needs to be available to get things done, right? And so I've had, recall clients who ask me, right, I'm going to pick my siblings to be the executor, right? But my siblings are overseas. Is that a good idea? Obviously not, right? If everything is going to be done over here and the guy is overseas in a maybe different time zone, that's not a good idea, right? So again, they just look at one dimension of the equation, which is the trust part, okay? Then next is competent, right? Is the executor competent enough to be able to handle stuff? Do they know what to do? If they don't know what to do they know how to find out what needs to be done, right? Where to get certain information, where to ask for help? Are they smart enough to be able to make some reasonable decisions? Like, for example, if I'm going to receive all these monies, I should probably set up a separate bank account as opposed to put everything into my bank account, right? And then my money is my money, your money also become my money, right? And then don't track it, don't record down what's going in, what's going out, right? And even if they're willing to do that, will they be able to do that for the duration of time that they're executing this, right? It could be many months and days, so it's a lot of work to do, right? So are they competent enough to be able to play this role effectively? Because if they're not, again, potential delays that will happen. Okay, next, the next C here is conflict, or rather the avoidance of conflict, right? Here's another example of where, let's say a husband and a father and mother may want to pick their eldest son to be the executor of the estate, right? And so there's this potential conflict, right? Because the eldest son is also likely to be a beneficiary of the estate. And so the problems that can arise from that is that if there is a perception that the executor, who is the eldest son, is acting in his interest as opposed to the other beneficiaries, his other siblings and stuff, right? Then that could cause disharmony among the family members, right? Reminds me of this case which I shared in class of an advisor who was asked to handle the estate, right? Because we all know, right? Financial advisors all know how to handle estate admin stuff, right? Of course not. Nobody knows how to handle that, right? Unless you're in this space. So even though you're a financial advisor, you are no different from anybody else, but because you wear the financial hat, you are supposed to be handled that. And so she took on the responsibilities, right? And so in that situation, the uncle was not very wealthy, but passed away because of an accident. And as she was handling the estate, she discovered some insurance policies. And because he passed away with the accident, and those were PA plans, suddenly the estate became a millionaire estate. Guess what happened after that? Yes, suddenly everybody is interested in getting the payout. Hey, why are you sitting on it so long? When are we going to get our money? Are you trying to cheat us from our share of the estate, or because you're the one handling it, right? And they hounded her so much to the point where eventually they're not on talking terms anymore. Once the estate settled, they don't even visit each other during Chinese New Year anymore. Okay, so these are the things that can happen, right? Another dimension of this no conflicts part is this, right? Where if I pick the executor, and executor has some conflict, there could be undue influence by other family members, right? If the adult son is married with a daughter and maybe he runs into some financial difficulties, then there'll be the temptation to tap onto these assets and use it for himself first, then I will pay back later or something like that, right? Again, to the detriment of the other beneficiaries who may be too young, who may not fully understand what's their rightful share, they can be taken advantage of, right? And so there's the risk of conflict, right? I guess one of the keywords I used in what I was sharing just now, right, is the idea of perception, right? I'm not trying to say that your beneficiaries are all out to cheat all your other beneficiaries, right? Or your appointment holders are trying to cheat the beneficiaries of the share. But the point here again, and that links back to the story I highlighted about the advisor, right? The financial advisor rep. If there's a perception, right, because the people outside don't see what's going on, they don't know the amount of legwork that needs to be done. And so they feel that the person is not acting, the appointed executor is not doing their job well, not handling things properly. That's where problems will happen again, right? As long as there's a perception, it's very hard to correct sometimes. Again, these are all lay individuals, so they don't know what's the right process. They just think, oh, this is what I think should happen, right? And if there's a difference in opinion, again, problems can arise, right? So when people pick their executors, our job is to highlight to them, right? These are the conflicts can happen, show some of the case studies that you see inside your lecture notes on such cases. And you notice a lot of these sort of fights that happen all tend to be family members suing each other, right? And of course, your clients always tell you, no, my family is not like that, right? We can do our best to educate and share, but end of the day, the client is the one that makes the final decision. So don't, if they still decide to do that, at least it's an informed decision, right? Minimally, what I'll say is, okay, we'll get to the possible candidates later, right? In terms of who can we appoint. And finally, the last one, of course, the most important is perhaps trustworthy, right? For most clients, that's all they think about, the trustworthy part. I trust my son, my daughter, I trust my spouse. But that's definitely not all, right? So it's something important because literally all the assets that are owned by the client, owned by your client, the testator, is in the control of the executor, everything. All your bank accounts, monies, insurance payout, investments, real estate property, everything is inside there, okay? So you really want to consider this criteria and have that discussion with the client, right? Linking back to some of the important things that we're trying to do as estate planners, right? Having this kind of discussions is one of the ways that you can demonstrate your skill as a estate planner, right? Again, if you go to a law firm, they just give you this form, you fill in the name, but they never have this kind of dialogue with you, right? This is one of the ways that you as a estate planner can differentiate yourselves from the lawyers, right? By having these kinds of conversations, right? Helping the clients think about how they want to pick their executors and not just, pick my spouse. Spouse not around, my older son, and that's it. Okay? So who are the possible candidates? these are some of the possible candidates, where they'll pick their spouse, their siblings, an adult child, some trusted friend, or a professional, right? So one of the key things when we discuss that is always the option of having a precepts trustee as your final substitute, right? And that's an important point to bring across to your clients, not because you're trying to acquire the AUM so you get some ongoing trustee fees when the estate is handled. That's a nice side effect of doing this. But more importantly, it's about giving your lay executors, right? End of the day, as I said, what's commonly done still is most people still end up picking some family members to play the role, right? Part of it is to try and minimize the fees. Part of it is is somebody that they trust, understand the family circumstances, and those are valid points, right? But minimally, by having a corporate executor as your final option, it gives you it gives these lay executors a way out. If they find that the estate is too complicated, too difficult, right? They can give up the responsibilities and not feel guilty because the corporate executor is able to step in, take up the slack, and see the case through, right? Reminds me of the Franklin Heng case, right? The CEO guy who died because of a botched liposuction, right? His case was complicated, right? You don't necessarily have to be something so complicated, but if there's an overseas assets or some problematic beneficiary or some asset you don't really know how to deal with, like, I don't know, cryptocurrencies or whatever, at least with a professional in place, if your family members are unable to complete the case, right? Like in the case there was court cases that they had to see through and it took over 10 years, right? Your lay executors may not be comfortable to take on that long duration of executor appointment or to handle other cases, then consider a corporate executor as a final option, okay? Another thing that can happen is as you're discussing this with the clients, your client may immediately feel, I don't want to burden any of my family members about these appointments, and so I'm just going to go straight to corporate executor, right? And that also works out. So at this point in time, in your own worksheets, think about who you want to pick as executors, right? Consider your primary executor, your first substitute, and if you understand how the precepts costing works, you can name up to 2 levels of executors, right? Your primary and your first substitute is included in your costing for your wills. So at least put that in your will. Okay? Yes, question? Yep. Oh. Okay, so let's go back to the earlier slide. Oh, by the way, we'll be sending out a summary of some of the slides at the end of it in the worksheet. Oh, yeah. You have it ready? Okay. Yeah, sure. Okay. So I got this case that has happened. It's a rather unfortunate case, which kind of addresses that issue, right? So again, the lawyers tend to be instruction takers and they rarely guide the process, right? They'll ask you, for example, give me the list of assets. You give them a list of assets and liabilities and they just act based on that. They don't go through the details of understanding whether that's all and stuff like that. And so what happened in this case was the client passed away without a will, right? It was a sudden death of the husband. The wife was sort of my client. Husband passed away suddenly, and so she engaged a lawyer to handle this case because she doesn't know what to do. After obtaining the letter of administration, she started distributing assets, but a couple of months or about a year plus later, there were a lot of creditor claims on the estate. So even though she has received that, the lawyers didn't do a thorough job of working with her to figure out what are the potential liabilities and stuff. And so now she's stuck with, I got all these claims from the banks and everything on the husband's estate, but I redistributed the money out. So it's a problem, right? Unfortunately for us estate planners, a lot of time, by the time you reach the final state, right, our job is a lot preventive. Our job is preventive, right? By the time you reach there, a little bit too late, it's lawyer's job already. And again, nothing against lawyers, but they make a lot of money then, and this kind of problems happen. Okay. So understanding the process, preparing your clients, having their asset listing, all that, and listing of assets and liabilities are things that we can help our clients prep to make it ready. And so that's, again, lawyers tend to be a bit passive. when handling such matters. Right. Another question there? Mm-hmm. $4,000 a year times 10 years, $40,000 in fees. Sounds like a lot, right? For $1 million estate. Does it sound like a lot? Now, nobody likes fees, right? So the question is about trying to help the clients understand the value of having this professional executor, right? So let me reframe it in a slightly different perspective. If the size of your estate is smaller, wouldn't every single dollar be a lot more valuable, right? So the question I will ask the client is that if your estate is like maybe, I don't know, $300,000, $400,000, and you're paying $4,000 in fees, that's like maybe 10% of your estate, right? The question I will ask the client is, I'll phrase it this way, right? If you appoint family members and they're managing this for the next 10 years, and they don't do a good job, after 10 years, are you sure that whatever money you left behind are still going to be there? Can your beneficiaries afford to not have the inheritance available to them, right? For a professional trustee, if they have proper accounting, they have audit trails, they're regulated by MAS, they're audited by MAS, and even if you say the employees themselves take the money and run away, there's recourse because you can sue the entity. They are required to maintain adequate professional indemnity insurance. So there's somebody to chase. But if your executors, one option is the executors take the money and run away. Want to sue also cannot find. Let's say they're not so malicious, right? They just, I don't know where's the money, don't know what account it's spent already, right? And so you sue, they become bankrupt, and you still don't get your money back. Okay, so it's about helping the client to understand the value of what the corporate executive brings. It's again not for everybody, right? There's no one solution fits all. Some people are just allergic to fees. But I think it's about helping them to recognize that there is the importance of preserving that capital, having it professionally managed, especially when there's not a lot, right, to go around and you can't afford that wastage. Then, yeah, that might make more sense for the client. Okay, it doesn't solve the problem all the way, but that's one of the ways I will tackle that question. Okay. Yeah. Okay. 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 Congrats. Really covered in class, by the way. Anyway, okay. Okay, anybody else remember before I answer? How do you write it? Correct. Section 10. Yes. How do I name them as beneficiaries? That's, I guess, the question. Yeah. Anybody? Right. Don't name them. Just say I want to give equally to all my children. So you don't have to name them. It's one of the options in your beneficiary section 6. You can just say my children from that particular spouse. And so this provides a bit of longevity to the will. So in case you have other kids, right? Maybe you're thinking twins, but suddenly triplets come out. Oh, still taken care of. You have other problems, but that's a different issue. Okay? So you can address it by children, right? Of course, as part of the ongoing process, you may want to revise your will eventually to name them specifically if you have some specific gift to make to them, for example. But if not, you can draft it as of now. Refer to them as children because you may not have decided on the names, you don't have the NRIC or birth cert number, and they can still be provided for. Specifically back to the wills part, there is this section where you can say, especially for your case for males, you can say, even for unborn children, they should receive a share. Section 10. Okay? Yeah. Good point. So when it comes to the planning, if you're dealing with children, you can still name them as beneficiaries, but you may want to think about using a trust structure to give to them instead. Okay, then your thinking will be, okay, what assets are going to be there? Probably part of your residual estate. You will think about who is going to be the trustee. Would it be your surviving spouse or somebody else? We'll get to the guardian parts and have that discussion. Yeah, but that's part of the consideration to have when you're thinking about giving to minor beneficiaries. Okay.
For personally, if I die alone, so figure out where the money goes. My children, like, they're very young. They won't be able to control, they can't exactly own the money. But they can own it, but they can't exactly use it. So obviously I'll put it in a trust. But at the same time, if I could pass away, let's say 30 years from now, and I didn't touch my will, and they're already 30 years old already, so technically they can use the money as they see fit. So, but that will, one will be designed to put in the trust, one will is designed to keep in the.
Yes. If you 30 years, you never revise your will.
Things happen, yeah, talk about it.
Yeah.
I mean, people, yeah, I can imagine people who don't revise their will for 30 years.
So that's called mistake.
Yeah, on the condition that my children be of a certain age, put you in trust, after a certain age, you can then directly.
Yes, everybody here should know. Testamentary trust. Yeah. Near the end of the page, near the end, there's a testamentary trust. Your trust, it will say how long the trust is supposed to last. At the end of the trust, who to give to. So we'll get there a little later. Okay, yeah. Oh, because I'm rich, I will not cheat. Interesting premise. Okay. Yeah. So again, remember, objective is we're not trying to get them. Our goal is not to get them to pick precepts as a corporate trustee, right? Our goal is to help them make an informed decision. That's the best we can do, right? We're not trying to grow our AUM. I mean, it's nice if it happens, but end of the day, if they still decide their family members, so be it. I think those with, there's no such thing as too much money. The more money you have, the more you want, because then, oh, the other guy got a bigger house than me, he's got a bigger car than me, and there's always. So the fact that you're rich doesn't mean that takes away the temptation for abuse. Circumstances happen, and so we should consider that. Yeah. Again, I'm not trying to say that you should always pick a corporate executor to handle the estate, but it's about understanding the risk, get them to think about their risk. They understand their family members better, because we, as estate planners, we don't know the family dynamics, right? We share stories and examples of things that have gone wrong in the past. The question is, does the client think would these kind of situations apply to them, right? They would not think about that. They probably don't want to think bad about their family members, right? But they really know the inside story, right? We don't. At most, we can help them realize that there's a potential problem. Okay? Yes. Yes. Okay. So in the EWF, you'll see that there's an option to make a gift, right? And the gift can be in two forms, either a lump sum gift or periodic gift. A simple rule of thumb is that for executive appointments, they tend to be a bit shorter duration. So a lump sum gift might make more sense. Again, it's a token of appreciation. So it's something that we ask our clients, right? Now, whether to give or not, there is no right or wrong. Consider some scenarios, right? If the executor happens to be the spouse, do you think you need to give a token of appreciation? Probably not. Why? Likely be a beneficiary, right? So in those kind of situations, I'll say no need to, right? I'll still ask anyway, right? Do you want to give a token or not? Then no, my spouse, Give her a token. No need. Okay, no need. Yeah, as to how much, no right figures, right? It really depends on the dynamics of the relationship, right? Are they, how close are they? How distant are they? How much work, how complicated the estate is, how much assets are there. There's no right way to put a figure. If they don't know, just throw a figure first. How about 50,000? Oh, so much. Can be lower, sure. How much lower? 30,000, okay. No, 5,000, 10,000. Don't give like $1.50 or something like that. It'll be a bit insulting rather than a recognition. Yes. Okay. But having said that, if you read the Probate Administration Act, the executor can apply to court for up to 5% of the estate. Right? They do have to justify to the courts why they need that. For example, I have to take no pay leave, right? And I've used up all my no pay leave already, and so I don't get paid for all these days I'm handling this case. So they do have to explain to the courts, but up to 5% of the estate. Okay. All right, so we are just done with executors. And I don't think we'll finish this case. Okay, let's move on quickly. Next part is guardians. Okay, so for guardians, we're going to look at a couple of things. We're going to consider some of the common candidates for guardianship. We'll talk about another dimension of that, the issue of guardian versus trustee, and then understand the responsibilities of the guardian. So similar approach we're going to take. What does the guardian need to do, right? So the guardians, as defined by the Guardianship of Infants Act, there are certain priorities that will happen. By default, the surviving parent will be a guardian, right? And so if you're happily married, then it's probably not a issue where husband and wife, if husband passes away, the wife becomes guardian of the kids. So that's the natural thing. As a result, in your wills, you never have to name the surviving spouse to be a guardian. Here, we're talking about the second part here, which is the testamentary guardian. Okay, so testamentary guardian is basically where in the will you name somebody else, right? And this is a good talking point on how you can perhaps start the estate planning conversations with your clients, right? If your clients haven't done their wills but they have kids, then you can start a conversation by highlighting to them, right? If you don't draft a will, the will is the only place where you can pick your guardian. If you don't draft a will, means you don't pick your guardians. You end up with the third case where the courts will be the ones that pick the guardian for you, right? And in an extreme situation, the guardian could be a foster home. Okay, and that's certainly far from ideal, right? And so, as an expression of their love, getting the wills done, naming this guardian is an important step for them to protect their children, right? So that's a good way to start the conversation with such individuals who have never done their will. So it's not from I don't have a lot of assets, my kids will be well taken care of because, and so on and so forth. It's really about naming that guardian, okay? So when we think about guardians, there are two scenarios under which this guardian steps in, right? If I name this testamentary guardian, scenario one is act with jointly with surviving parent, right? So to me, this is the typical scenario for that is when I have the husband and wife. In this case, their marriage perhaps is already on the rocks. They're very divorced. And so the scenario here is where let's say the mom has custody of the kids and she passed away. She's worried that because the surviving parent, the ex-husband will be automatic guardian, the kids will end up as second-class citizens in that new family unit, right? And then maybe they're taken advantage of, they're not given their rightful shares of the estate and stuff like that. So things can go wrong. So this is where the wife or the mother can appoint a testamentary guardian, let's say her sister, to act jointly with the surviving spouse. Okay, and if that surviving spouse never does anything, the sister, testamentary guardian appointed, can take on the responsibility, look after the child, right? Important thing to note here is that the appointment of guardianship, right, this is separate from the monies and inheritance part. If the person accepts the guardianship, they are accepting the responsibilities of providing and for the child as well, even without any inheritance, okay? So that's something to keep in mind. We'll talk about the inheritance part a little later, but that's the assumption. The guardians will need to provide for the child, right? The second part of it is at the bottom here, we act on demise of both parents. So if they're happily married, chances are their planning considerations will be the second scenario, right? I'm probably okay if I pass away, my wife takes over to look after the kids, or if she passes away first, I look after the kids on my own without anybody else, that's probably fine, right? in the case of a common disaster where both parents pass away, right, this is where your testamentary guardian, that's when you want the testamentary guardian to step in, right? So if all you have kids, who do you want to pick as your guardian, right? Think about this part. And this problem is particularly complicated, especially when you're dealing with parties who have been, well, maybe PRs or naturalized citizens, right? They're not born here, their family unit, extended family units are not here. It becomes a bit difficult for them to decide on somebody, right? But if they don't, again, their kids will be at risk. So it's still in their interest to pick somebody inside their guardianship, to point at this guardianship. Okay, so the scope of the guardianship is this, right? When they are guardian, then their job will be custody of the kids, right? Look after the kids, be responsible for the kids, make any decisions for the kids. Is to provide support and maintenance for the child, right? Feed the child, clothe the child, make sure that they have food to eat, clothes to wear, a shelter for them to stay. So that's the responsibility of the guardian. They are typically responsible for making education decisions, which school to go to, what course of study to go to. As long as they're minor, that's the role of the guardian. And of course, also the financial parts, right? Pay for the school fees, textbooks, any other resources that the child may need. Finally, the last part's on medical, right? If the child needs to make, as a minor, they are unable to make decisions on what course of treatment to go to decide on, the guardian has to be the one to step in, right? Now, a practical point on guardianship is this, right? Imagine this scenario, husband and wife, common disaster, passed away, and let's say they are living with the mom, the wife's parents, right? A natural situation will be the grandma, assuming she's involved with the upbringing of the child, will carry on looking after the kid, right? Bring the child to school, provide for the child, feed the child. But if this guardianship appointment was never done because they never wrote their will, right? The risk is this, right? When, let's say the child meets in an accident and they need the guardian to step in to make that medical decision, then you realize, hey, there's no guardian because it was not appointed. Right? Parents already passed away. This is where the problem happens, right? It's usually this case. Normal circumstances may not be a problem, right? Because the school may still recognize the grandma and allow the grandma to take the child back to school, primary school, back and forth, and stuff like that. The grandma can go for tea break also. So everything works normally under normal circumstances, right? But the problem why we plan is to plan for these funny exceptions, the outliers, and when it happens and you're not prepared for it, this is where all hell breaks loose and all the problems happen, right? So don't take it for granted that yeah, I don't need to appoint guardians. My parents will know what to do to look after the kids and stuff like that. Okay. Before we go for a break, let's just move on to the next part, and then we go for a quick break. So the second part is guardians are to look after the kid, but you're also leaving behind funds for the children, right? The question then becomes, who looks after these funds? And you have basically two options here, right? The guardian and the trustee can be the same party, right? Can you all imagine what's the advantage of this approach? If your guardian and a trustee are the same person. It's easy, right? I need to look after the kid. Money is there. I just use the money and look after the kid. Fine, right? What's the problem with that approach? Yeah, no checks and balances, right? The guardian has access to all the funds. And so after 5 years, 10 years, when the kid becomes an adult and asks, uncle, auntie, or whoever, can I have my inheritance? They can simply say, what inheritance? All spent on you already. Nothing is left. And what will the child do? In some extreme cases, the child will sue and the executor is unable to provide records. You see that case study in the precepts training. The guardian ends up being bankrupt. Okay, but of course, if your kid doesn't do that, it's very nice because it respects the guardian because providing all that care for them over the years, but not so financially savvy, then they could lose their inheritance, right? Or at least a large part of the inheritance. And it's not your $30,000, $40,000 in fees. It's like 40, 15, 80% of the inheritance could have been misappropriated, right? I just don't know where it went to. I didn't track it. Okay, so that's the risk, right? What's the solution to that? Split the roles, isn't it? Guardian and trustee, separate parties. But can you imagine the problems with that? What's the problems? Disagree? Okay. So you split the role because you want check and balances, right? And every time there's check and balances, the guardian will say, "Alamak, every time I want to ask for money, the guy asks me for receipt this, ask for this letter, ask for that documentation, ask for disclaimer or whatever else. So troublesome. I don't want to do it anymore. You want to look after the child yourself." That can happen, isn't it? Right? And so there is unfortunately no right solution, no easy solution sometimes. And so it's about getting the clients to think about this and don't wait until by the time they pass away. Sometimes it's just too late to make these plans, right? While they're still alive, both parents are around, they can start thinking about that. If they have difficulty picking somebody right now, then maybe they need to start thinking about cultivating that kind of relationship with some friendly parties, right? Neighbors, good colleagues, good friends, staying around them. If they're involved with some religious organizations, maybe finding parties over there that they can cultivate that kind of relationship with to play that role of guardianship in the event of a disaster, right? Common disaster. So these are things that they can do right now, and the value add that we have by having these conversations early is that they can start embarking on this, right? It's not going to happen overnight where they can find somebody else to play that role, but by having this discussion, they can start thinking about it and maybe come to a better solution, be in a better state than they were before having this talk through this issue. Okay. So with that, let's just go for how long do you need for a break? Maybe 5, 10 minutes. 10 minutes. Okay. Then we'll come back at 3:15. For the rest, we're not going out. Think about your own guardians. If you have kids, who do you want to appoint? And write that down your worksheet.
Insurance nomination. Nominate minor kids. They can't receive.
Below 18, yes.
So I think the nomination that says that you'll be given to the guardian.
That's one of the options. Basically, the insurer decides. They could hold it back and not give, or they could give to the guardian. So there's no regular, the trust setup you need to refer is actually kind of there. I did add in a little bit more, but the bulk of it is taken from there. So the starting point for giving is, if your client is thinking about their assets and what stuff, in fact, if you're thinking about your own stuff, one option you have is give for your life, right? So that's useful for things like your collections, right? Your jewelry, you've got your stamp collection. You remember your case study, I've got the prize golf set. Maybe I want to give it right now while I'm alive, right? So that's something to consider, whether for whatever assets you have, that's one way to give. Next option we have is to give via your residuary gift, right? I added in a bit the description where I put there residuary immediate gift upon death, right? So the other way to think about it is when I give, I can give it immediately when I die, right? Or give it only when I die, rather than in my lifetime. But I do that via the residuary clause, right? So this is where my famous phrase, 50 to spouse, 25 to son, 25 to daughter comes in, right? I give that way. That's one way to do that, right? And that's dealing with the bulk of your assets, right? While it's the lowest priority gift, right? It's called residuary because it's whatever else I did not give away. It falls into the residuary estate and therefore goes to this group of beneficiaries. For most people, this form of giving is the main way of giving, right? So when I do planning for clients, I usually want to start off with the residuary clause, okay? So that's another way of giving. I can give via the residuary estate. Another way is I can do also immediate gift, but I give via a specific gift. Usually this is where I deal with certain problematic assets, or when I'm trying to give something very unique and special, right? Maybe I have, like in the case study, I've got a prize golf set I want to give away. I want to make sure that that beneficiary knows I'm giving this particular item, right? A valuable watch or something that I want to be very clear it's meant for that one party. So I can use the specific gift to do that, right? So again, it's an immediate gift that happens upon death. It's also a lump sum gift. So these are the two ways of giving, right? Via residuary or specific gift, it's immediate upon death, and it's in a lump sum format, right? So these are two ways we can give. The third way, and from here onwards, is where we use a trust structure. Okay, And that's where I'm considering, I want to stagger the payout. I want to give everything immediately because they are not ready to receive everything, right? I want to impose certain conditions. They are not ready to accept all their stuff yet. So I want to incentivize or disincentivize certain type of behavior, right? I want them to go to university. Only when they go to university, then I give them certain distributions, right? So that's the staggered conditional gift, but I want to do that only upon death. And that's via a testamentary trust, or TT in short. Okay, so this is a good way of giving the benefit but not the control, and that's one of the powers of the trust, right? A lot of times, in fact, I was just dealing with that this morning, right? I got this ESP calling and asking, can I do this in my will? I want to write my will. I want to give the house to my kids, but I don't want to dictate what they do with it. I want to give already, but then let them, I want them to be able to decide whether to sell or not, or don't sell, or distribute it. I want them to decide. But that's the problem, isn't it? Once you give the asset, you lose control. You can't tell them what you want to do after that already. If you give, they decide. If you don't give, then they never own it, right? But if I want them to enjoy it but not control it, this is where I can use a testamentary trust to deal with it. Typically, a TT, a way of differentiating that is to, if I just need simple instructions, then a good starting point is to start off with a TT, right? When I need this kind of control. But when I have a little bit more, I want a bit more control, I need a little bit more features and benefits, then I can consider a conditional or staggered gift using a living trust instead, right? So you can think of this as an escalation of the gift, right? On top, lifetime gift, when you're alive, may be very little cost to do, right? My watch passed to you, that's it, doesn't cost me anything, right? But right on the other end, to handle this kind of living trust, then I need to draft out the trust deed. It costs more, but I have a lot more control over it. Okay, so it's good to handle more complex controls where I may need some kind of protection potentially for the settler, your client, or the beneficiaries, right? And I can deal with other kind of conditions like other triggers, right? If I lose mental capacity, I want to deal with that. I only want to give when I lose mental capacity, right? Again, some of the earlier forms of distribution cannot handle that case, right? So these are some of the broad ways. And in a sense, what we're trying to do with estate planning is talk through the clients, right? For all the stuff, right? All of it or selected items, which of these methods make the most sense, okay? Now, how do I decide what makes the most sense? This is where the next set of conditions come into play. I'm going to refer to my notes here because I didn't want to squeeze everything in. Plus, I didn't have time. Okay. So this is a list of things that we want to keep in mind, right? When we're trying to decide which form of giving, these are the things we want to keep in mind, right? For example, need for legal enforceability. Now, this is something very common. I always see, which is clients will say, right, when I die, I'm going to give all my assets, let's say, to my older son. He's an adult, so I give to him, right? But he's got two other siblings who are minor, and I can't give to them, so I just give to my older son and says, he will know how to look after his siblings. Have you encountered that before? Right? I'm sure all of you have, right? And I do that because I don't want to pay trustee fees, right? Or take calls. So what's the problem with this approach? How would you tackle that? When the client says, I just give it to my son or give it to that person, they will know what to do. They will know how to look after the other beneficiaries. How do you tackle that? By highlighting problems, right? What kind of problems will surface if I do that approach? Right. The point I'm making here is legal enforceability, or rather in this case, the lack of legal enforceability. If I make the gift to that beneficiary, it belongs to the beneficiary. They decide what to do with the assets. It's not, I can't tell them what to do with it anymore. I mean, I can tell them, but whatever I say has no force behind it to compel them to do whatever I want them to do, right? And that's the problem. And so when they encounter it's their asset, they can simply say, no, Dad intended to give this to me. That's why he wrote in the will, give to me. It's not meant for my other siblings. I'm going to use that to start a business, travel overseas or whatever. And too bad for the other beneficiaries, right? Now, again, we're not saying that all the beneficiaries are evil and trying to cheat their siblings or whatever. But again, if there are undue influence from spouse, if they get into financial difficulty, then there's certain added incentive for them to take action for their own benefit against the other beneficiaries, then they will do that because they have the right to. It belongs to them. You cannot enforce your wishes on them anymore, right? And that's the first issue to think about. Okay, next, transaction costs. Right, when we implement some of these plans, most of these plans involve some kind of cost, right? Different level of cost. Will drafting one clause maybe add $100 to your cost. Do a living trust, 5,005 plus GST. So there's a big difference of cost, right? Other things, other forms of transaction costs as well is, let's say I make a lifetime gift. If I want to give property while I'm alive, high transaction costs, right? I have to pay stamp duties to retitle the property to somebody else. So doing a lifetime gift is expensive. If I want to put that property into a trust during my lifetime, 65% ABSD, right? Very expensive. So what's the more cost-effective way to do that? So the question is when to give, how to avoid this transaction cost of property. Now, we can sell away, then somebody else bears the cost, right? But property, everybody loves to keep, right? Because we can enjoy capital appreciation. So the best way to transfer property is upon death, free of stamp duty, right? If I put the property into a trust, no ABSD to pay for. If I put the property into an LT, a TT, no stamp duties to pay, and that's the most cost-effective, right? So part of the consideration to decide which of these distributions that we saw earlier to use is the transaction cost. How much does it cost for me to set up? To use the tool, to set up the tool, or to effect the transfer, right? If it's shares, right? Another common scenario, if I own shares, right, titled jointly with my spouse, right? If I want to shift the shares around, I got to pay some admin fee, but it's not a lot, right? Maybe $10 per transfer, right? It's not so much compared to property, which is up to 2, 3, 4% of the value of the property, which is much more significant, right? So some things we can transfer during our lifetime, it doesn't cost a lot. Some things it does cost a lot. Yeah. Yes. If you recall your TT, there are 3 forms of trust, right? Standard trust, trust for sale, trust for life tenant, for immovable property. Yes, you can put inside there. In fact, when it comes to property, if the intent is at the end of the trust to eventually transfer the property to the beneficiaries instead of liquidating and then give the cash, right? We want to transfer the property to the beneficiaries at the end. The TT is actually more cost effective because the entire transfer from estate to trustee, trustee to beneficiary is free of stamp duties. We learned that in the trust part of the course. If we do that with a LT, the first leg of transfer is free, right? From the estate to the living trust, because the instructions of the will say transfer to the trustee, that's free of stamp duties, right? But the final leg from living trust trustee to the beneficiaries, it's not a transfer upon death anymore. It's just a normal retitling of the property. That's subjected to stamp duties. So sometimes that's part of the transaction cost you got to keep in mind, being aware of these differences. Okay, that's transaction cost. The next, tax implications, right? Certain assets we own, there could be certain tax implications. In the sense, for example, if I'm classic example, if I own US assets, US domicile assets, real estate, stocks and shares, if I buy US ETF, I buy Apple shares directly on the various international brokers. If I own assets above 60,000 US dollars, I'm subjected to US estate duties when I die. Okay, it's a progressive tax from 18% all the way to 40%, depending on the size of the value of the asset. So there are certain tax implications, right? This could be incurred by the estate itself. When I die, the estate pays it off, then give to beneficiaries. Another dimension, depending on who the beneficiaries are. If the beneficiaries are in Japan, for example, then when I make a distribution to the Japanese beneficiary, Japanese government will take 55% of it in terms of inheritance taxes. So being aware of that is, again, will help us think about how to give, right? So maybe structuring a trust and not giving the asset directly might be a better approach. So that's tax implication. Next, beneficiary. Another important thing to consider is to ask this question, right? Does the beneficiary benefit from the gift? Okay. So an example I'll give for that would be this, right? If I pass away, again, if I don't plan for it, and I have an investment account, I have unit trust and stocks and shares, then 50 goes to wife, 50 goes to 25 to son, 25 to daughter, right? But my wife don't know how to manage investments, my kids are all minor, then the problem is that all my investments get split that way. I may have to pay some stamp duties to do the transfer, but it doesn't benefit anybody, right? Because they don't know how to manage it, right? So maybe a slightly different way of dealing with it might make sense. Maybe sell the stocks and shares, give cash instead. Maybe they appreciate that more, right? If the portfolio is sizable, maybe have it professionally managed, route it to a trust, appoint an investment manager, which could be any of you in the financial advisory space, to handle that, and that builds your AUM. That might be beneficial, right? Have it professionally managed, you grow the portfolio over time, generate income for the beneficiaries. Yeah, these are options. So thinking about whether that gift makes sense, does it actually benefit them? Or could it spoil them, right? If I make a gift to the beneficiary and they get $2 million, now instead of using that to go and study and enhance themselves, they go and buy a Bugatti Veyron, then drive on Singapore streets, crash and then die. Did the gift really benefit them or not? Right? Perhaps not, right? So thinking about the beneficiaries and their characteristics, right? And I got you all to think about your own beneficiaries. Think about these kinds of issues. That's part of your consideration. Okay, next. Are there negative effects on the beneficiaries? Okay, if I make the gift, does the gift spoil the beneficiary, right? If I make the gift to them, will they be targeted by scammers, right? There's this case study again inside the notes where this lady, her husband was a taxi driver killed in a car accident, right? There was reported in the papers, massive outpouring of benefits to them. And then because her details were reported, at least her name was reported in the papers as the spouse, a lot of people approached her with all kinds of investment schemes, right? So they get targeted by such things, they can be taken advantage of, scammed, and then lose their inheritance, okay? Yeah, another example I recall is the Changi Airport case, right? I think it's again in our notes, the lady received lots of monies from the insurance payout plus the donations from all, and they lost everything within that 1 year, right? So it didn't really, there were the negative effects, right? They didn't know how to manage money and end up squandering all the money. So putting some thought about how you want to handle the distribution, does it benefit them? Would there be negative effects? Would be something that we need to post to our clients, and these stories and examples are how you can get them to think about it, okay? Next will be the complexity of instructions. When I want to make a distribution, is it as simple as when I die, just give it to them and that's it, I'm happy with that, then maybe a will is sufficient, right? But if I want to impose a lot more controls, right, this gift is only meant for them to go to study in Oxbridge, right, Oxford or Cambridge, cannot do anything else, right? They must get into law in Oxford and Cambridge. They don't, then don't give them any money or some kind of detailed instructions like that, right? Or they must come and visit me at my grave every year. If not, then they don't get their yearly distributions or something to the effect, right? If I want to have all these conditions, there's a lot of things I want to say. I want to incentivize certain behavior, disincentivize certain behavior, then a direct gift through wills probably won't work so well, right? So if the client has, end of the day, is their assets, right? They may have certain views of that, like a business and stuff. So if there's a lot of these kind of conditions, then some kind of trust structure might work a little bit better. Okay, next, privacy and confidentiality of their instructions, right? If you have a family in Batam, my favorite phrase, you may not want your family in Singapore to know. And so if you use your will to give to them, then suddenly everybody, all your other beneficiaries in the will be able to find out about these other family and then start inquiring about who these parties are, and in a sense, you're potentially washing dirty linen in public. That's not so ideal, right? So again, if your client's a bit high profile, some kind of celebrity, then maintaining some kind of privacy about the distributions, about the assets may be desirable. So wills may not work so well, right? Even though there's a testamentary trust inside there, but I may want to use a living trust to maintain more privacy. Okay, finally, asset protection. Does the client need to protect his assets against creditors, right? Again, two dimensions: creditors of the beneficiary, creditors of the settlor, right? The client, your client itself, right? If they need creditor protection for the beneficiaries, then anybody remember what's the key criteria for your trust to have in order to protect the assets? For the beneficiary first. Sorry? 5 years. Yes, that's more for the settlor. Right, so irrevocable trust is for the settlor, right? Because the principle of how it works is that once the asset is not mine as a settlor, it has to be in a trust, and it cannot be mine for at least 5 years. Then the asset is protected from my creditors. Okay. For the beneficiary, the key criteria is that the trust has to be a discretionary trust and not a fixed trust. That means there's no entitlement for the beneficiary to receive, right? And this form of trust can be either in a form of a living trust or a testamentary trust, right? So the keyword is it has to be discretionary. So irrevocable for settlor, discretionary for beneficiaries, right? Just remember these two. And so these are some of the things to keep in mind, right? So as we think through all these bits, you need to link that back to the solution, and we're going to look at some of the ways to do that right now. Okay, so let's start off with the residuary. As I mentioned, when I do planning for the clients, I always want to start off with that residuary because it's usually giving to the main beneficiaries, right? Even though it's the lowest priority gift, it's the main beneficiaries. And when we understand who the main beneficiaries are, this is where when we look at the individual assets, we can then determine whether they become a problem or not, right? Let me give you an example of that. In my residuary clause says, when I die, everything goes to my wife. If my wife is not around, then give equally to my son and my daughter. Okay, and my kids are, let's say, minor at this point in time. Okay. So if I have investment account, right, then the gift to my wife may not be a problem. If she's financially savvy, then the distribution of my investment accounts to my wife, 100%, via the residuary clause, is perfectly fine. I don't need to deal with it, right? But on the other hand, if it's spouse and kids, then giving half of the investment account to the kids who are minor and they don't know how to manage it may not make a lot of sense, right? And so by understanding who are the beneficiaries, right? And chances are your residuary clause will have a bunch of people typically, right? Splitting certain assets into a bunch of people may not be ideal, right? We'll see property, which is a classic case of problems with that. It causes all kinds of issues, and therefore we want to be a little bit more deliberate in our plans where we look at the specific gift, right? So that's why I always start with the residuary first. Once I know who they are, then I know whether I need to do some additional planning for specific gift, right? So let's go with residuary clause. Right, so as I mentioned, it's meant to distribute the bulk of your assets and to give to your main beneficiaries. And so if you can refer to your form, right, this is my own version. It looks something similar to that, right? You want to understand this here. Okay. This is a list I have for the listing of my beneficiaries. Maybe the intent here is for me to think through, right? When I list down all my beneficiaries, which you all have already done, hopefully, some of you all, at the end of your page, who are these people you want to give to, right? But when you're thinking about your beneficiaries, other than thinking about who they are, you also want to think about the concerns that you may have, right? So we ask our clients, right, if for your spouse, any concerns with your spouse, right? Usually financially savvy or not financially savvy, looking at what assets they have, that's the kind of stuff we want to ask, right? The kids, do they know how to manage money? Or they spendthrift? They're always trying to look out for the latest cryptocurrencies to invest in or buy the next NFT or whatever. And if I give them $1 million, they're going to squander it on these kinds of stuff. So that may not be ideal, right? So by thinking about who our beneficiaries are, when we look at the residuary clause, we look at who the beneficiaries, that helps us understand the kind of protection we may need to structure rather than to give them directly. Okay? So when we look at our beneficiaries, these are the examples of conditions we want to think about. Okay, can you all guess what they are before I show the next slide? Okay, the one on the top left with the hands. Elderly. So what's the problem with elderly? They are vulnerable. They may not be so sharp anymore. They could be taken advantage of. Okay, the one on the right, top right, spendthrift, right? Always burn money. Okay, on the left, bottom left, bankrupt, and on the right, delinquent. Okay, yeah. Receive the money and go and buy drugs or whatever. Right, so that's roughly this group of people. Or mental incapacity, okay, quite close. Vulnerable, I think, is the next one. Okay, so are any of the beneficiaries that you have thinking of giving via a residuary clause? Are any of them having this kind of conditions, right? Are they spendthrift, bankrupt, potentially bankrupt, right? Or are they delinquent, right? They are really involved with bad company. They got friends. The kind of friends they're keeping are not so ideal. They are heavily influenced by these negative influences or their friends that they keep, right? Or are they bankrupt, mentally incapacitated? Okay. The next few here would be special needs. Are there any special needs beneficiaries, right? For them, the implications is that there could be additional tools that we can use to protect the interests of these special needs beneficiaries, right? Are they vulnerable? They're elderly, they're vulnerable, they could be taken advantage of. Next, divorce. Are there any beneficiaries who are subjected to divorce, right? Then potentially some of the assets you're leaving behind for them could be lost to the outgoing spouse. Okay. Next, philanthropy. If your clients are a little bit wealthier, then they are thinking maybe I've already provided enough for my family members. I want to give back to society in some ways. Are we able to help them? Do we have the skill and knowledge to provide them with giving strategies that will make sense, right? There are, again, many different ways of doing that. Outright give on the will, through giving through your trust, or using donor-directed funds, or in the extreme case, even setting up a whole foundation, right? So philanthropy will be one thing. And finally, minor. If you have minor children in your estate, directly giving to them is probably not a good idea. It becomes an implicit trust, and there are a lot of limitations with implicit trust. Okay. So end of the day, residuary clause works this way, right? All your estate, everything you have falls inside there, right? Unless you have given some specific things away, they all fall inside there. And creditors will have the first right on your estate. So if you owe money, you have to pay money, in the famous words of Along, right? So if you owe credit card bills, outstanding mortgages, car loans, those things will have to be resolved first. And so part of the estate plan is to identify these liabilities, right? So when you're asset listing, you have your asset and liabilities, you look at these things and determine how are they going to be settled, right? And this is where financial advisory and estate planning goes hand in glove again. Financial advisory is able to provide the funds to take care of these liabilities, right? And as you go through the estate planning, looking at the assets, you may uncover needs that they didn't think about, didn't realize, right? Examples again would be in the form of tax liabilities for overseas assets, right? Or liabilities on the beneficiaries that are overseas, right? So you may want to provide some funds to offset the inheritance taxes that they're subjected to. Okay. So that's what happens to your assets. All creditors will take the assets first, then specific gifts, right? If there are specific things you want to give away, certain amounts of money to charity, certain amount of money to certain beneficiaries, then those are taken out next. And it goes down to finally your residuary beneficiaries. And that's where you end up with your main beneficiaries here, right? Let me just bring my mouse. Okay. So you get to this last part here. Okay, you end up with your main beneficiaries. So after all these assets are taken out from here, whatever falls that's left behind is your residuary clause. Okay. So these are your main beneficiaries, and other than thinking about main beneficiaries, what we're trying to do is to make sure that we have adequate redundancy. Okay. So in your worksheets right now, you have a bit more detailed ones, right? Let's take a look at the form. So it's broken up a little bit closer to how the EWF looks like. You have your main beneficiary group. So those are the main people you want to give to, right? So this is page 3 of your forms. So who are these people you want to give to, right? The main people that you want to provide for. If you're married, spouse and kids are probably one of them. Then as part of our effective will, we want to think about the next group, right? If that primary group is not around, right? For most people, if you're married with kids, spouse and kids are probably your primary beneficiaries, if they are not around, who else do you want to give to? And that's where your substitute groups come into play, right? So for me, what you see on the screen is a little bit different because it's my own simple version of the template. You can bet this number 1 to be your main beneficiary group. Then number 2 here would be, number 2 will be equivalent to your substitute groups, and then number 3 would be your final substitute groups, and so on and so forth. Okay. So the slots there allow you to put in your name or the people, so you can fill that in on your own. Who are this main group of people, and what share are they getting, right? So as part of your planning, you make sure that you have sufficient redundancies having this level. Then you make sure that you have all your tiers add up to be 100%, right? So whatever gift you make makes up 100%, right? Some people's distribution can be quite complicated, right? Depending on how close they are, first cousins get 13.5%, second cousins get 6.25%. Then I don't know how many second cousins I have. And make sure that you total out everything ends up to be 100% for every single group, right? If it's not 100%, either more or less, then it would be a mistake as well, right? Because if you're giving more, then where does the extra come from if it's not 100%? If you're giving less, then there's some assets that are unaccounted for, right? It doesn't get distributed. So must be exactly 100%. Then you want to consider how to distribute if Benny predeceases, right? So this is where your substitute parts in the form comes into play. If the beneficiary predeceases, right, who else do you want to give to? So again, the clients are probably not aware of it. They don't realize that they can do that. It's where we step in and prompt the clients, right? So for your own beneficiaries, please think about that and indicate how you want to distribute it, okay? And then finally, an option will be to consider a ultimate beneficiary. So in your final substitute group, right at the bottom, okay, here we show only 3 levels. Technically, there's no limit, right? In the actual forms, you can have there's any number of levels, but in terms of cost-wise, every groups that you have will be chargeable at 1 clause, okay? So it's important to have some level of redundancy, but balancing out with the cost. So your ultimate beneficiaries are for clients who says, I just want to give to my spouse and kids. I have nobody else to give to. Okay. Then suggest maybe a charity. They can give to a charity. Okay. At least end of the day, if a common disaster happens, somebody that they have elected receives their estate, right? If they have nobody else to put, then my name is John Sim Wei Tai. My NRC number is, just put my name inside there. Solve all the problem. Okay? I don't mind receiving it. Or you can put your own name also, either way, right? And when you do that, your clients will automatically think about somebody else they want to give to. Okay? Yep. Yes. Right. Yes. Yes. Okay. Yeah. So in my process, I would have sent a spreadsheet, something like that, to get the clients to think about it. So in your case, you already have your listing. So you look through that list and see who are the people you want to give to, the main groups that you want to give to, and the secondary groups that you want to give to, right? For some people, it's parents and siblings. So another way to think about this is, for me, when I do this planning, again, looking at who the structure is, I mean, who the family units are, assuming a typical structure of spouse and kids, right, as your typical family unit, then my 3 levels would be spouse and kids at the first level, parents and siblings as the next substitute, and then charity as the final substitute, right? So I will start off with that structure and then work with the client to say, okay, is this okay? Not okay, then let's adjust from there, okay? It helps because rather than to give them a blank sheet and then they start thinking, by giving them an initial structure which is reasonable, right? As I said, spouse and kids, parents and siblings, and then charity, like if you don't know, just put community chairs or something like that. Having the initial structure, it's easier to talk about it and change from there rather than to start with a blank piece of paper, right? So that's a strategy that you can consider doing. And you can do that by looking at the asset listing and the beneficiary listing first, and then slot in some reasonable names, right? What you think is reasonable. If you were in a client's position, what you want to do, right? Put that in first, and then the client, it's easier for the client to say, okay, this is okay, then move on. That's it. Okay. also by number of beneficiaries. One group maximum of 6. If you charge beyond 6, each 6 or part thereof is also chargeable at 1 act clause. There's a lot of names to type. Yes. So in terms of beneficiary, you can give to anybody, right? There's no limit. In Singapore, we have testamentary freedom, right? But when we think about beneficiaries, that freedom is also restricted. This is part of the course again, right? Restricted through this IFPA beneficiaries, remember? So if I don't want to give to spouse and kids, right, these spouse and kids potentially have a basis to challenge that disinheritance. So we need to be aware of that. Inheritance Family Provision Act. So in case you forget, it's again in the notes, your IPA beneficiaries refer to spouse as your IPA beneficiary. Then when it comes to kids, if you have any physically or mentally disabled children, they are, if you don't give to them, they have a basis to challenge. When it comes to your normal kids, it's based on, for sons, it's based on infant sons. If they are below the age of 21 and you don't give to them, they can challenge. For daughters, it's based on their marital status. As long as they're not married, they are still part of the family unit and they can challenge any disinheritance. Once they're married, they can't. They don't qualify anymore. So if you don't want to give to this group of people, in the will, section 10 allows us to state, I don't want to give to these IPA beneficiaries and give your reason why, right? For example, I can say, I don't want to give to my wife. I want to preserve all my assets for my kids. Why? Because my wife earns more money than me. She's got more than enough savings. She doesn't need my money. I want to keep it for my kids instead. So that's the reason. Okay. So that's about beneficiaries. Okay, so hopefully, yeah. Doesn't qualify. Is the problem, responsibility of the ex-husband. Yeah, your alimony and all that kind of stuff. Yes. First marriage. Yes. Yes. Only first marriage. Sure. Okay. What do you want to talk about? Don't include them in the will. Yes. So again, testamentary freedom, illegitimate child is not an IPA beneficiary, so there's no basis for them to challenge. And in the same light, parents also have no basis to challenge, right? That's, if you think about it, it's even more sensitive. If you don't give your parents, they can't say, hey, I'm your parent, how come I never get anything? There's no legal basis to challenge. Okay, so I can't say, hey, I'm your estate planning trainer, no, how come you never give me anything? No basis to challenge, same. Okay. Any other questions on your residuary clause? Right. So this is a most important gift, right? Because it's giving typically to the main beneficiary. So help a client think through that and potentially avoid issues, looking at the characteristics and then decide what's the best way to give. Okay. Now let's move on to specific gift, and this is perhaps the part that's very confusing for most people. Okay, so when you talk about gift, starting point for me whenever I plan, right, although I may not do a lot of the work over here, I start off by making sure that the client considers their non-probate assets, right? And these are the 3 common non-probate assets. Basically, these are the assets that bypass the will, right? I won't go into a lot of planning details for this. I don't think I have a lot of time to do that, so I'm going to just refer you again to your notes. Go back, look at your slides on that. But end of the day, it's about bringing this up. I don't do a lot of this work, right? Typically because, well, I guess I'm not paid to do it. I'll just ask the client, have you done your CPF nominations? Yes, okay, good. How about insurance? Done already not? Don't know. Okay, please show me what nominations you have. Generally for me, I would try not to use nominations as far as possible because I prefer to use the will to distribute, which is again a whole separate discussion I don't have time to go through. So for me, my preference is use will to distribute because it's where they look at all their asset distribution, right? Rather than just thinking about one policy. And plus, most clients don't remember what they give, who they give to, what policies they have. So very confusing. So So for those in the advisory space who automatically do nominations, yeah, again, I refer you back to the notes. You shouldn't automatically do that. There are a lot of other considerations. Okay, finally, jointly owned assets, right? So joint bank accounts, jointly held property, joint investment accounts, they can again bypass the will and belong to the surviving owner. So if your client has those, yeah.
Businesses like, for example, joint bank account, right? So normally people will fight that. Okay, maybe the elder son, so you're holding a trust for the rest of siblings. So you said cases that people win the case.
Yes.
Another one is like property. So joint property. So like people can still fight, or by right is the next to take the property. But any cases that people fight the case and we won the case.
Okay. So when it comes to these assets, while we classify them collectively as jointly held assets, right, the legality of these are a little bit different as well, right? When it comes to joint tenancy properties, because the joint tenancy is documented inside the legal ownership documents, the joint tenancy, in my personal opinion, is a lot stronger. So I've not seen it myself, I haven't really researched on that part, but I've heard of cases, or somebody has told me before that there are cases where there's a joint tenancy, there's a challenge, and the challengers succeeded. I don't know the details of the case, but apparently there's such things. But I feel that that's a lot harder because the documents itself, the legal ownership has really been drawn up that way. And that's as opposed to, say, things like your joint bank accounts. The joint bank accounts there's no legal framework for that. It's really just the terms and conditions of the bank, which you agreed to when you set up. So because of that, the legality of that gift to surviving owner is not as strong as a joint tenancy property. Okay, so end of the day, apparently there are both kind of cases where challenges happened before, right? And the challenges have succeeded against this. The percentage success, I have no idea.
But you put specifically in the will to say that this joint account, the money is specifically for you, or you're holding on trust for your the rest of the city. So there's no room for contest.
But there's always room for contest because the basic premise I always say is that if you don't intend to give to the joint account holder, don't have a joint account, right? But many people still set it up for convenience, right? And so this is where the problem happens, right? So there's these two scenarios. Let's talk about them. Let's start with the scenario you highlighted, Eric, which is I have a joint account. I don't intend to give the money to the joint account holder. I want to give to other parties instead. If I write that into my will, who will receive? Will it be the joint account holder or the other party in my will? What do you think? Joint account? Okay. So as far as we're concerned, the legal owner, while the person is alive, is the joint account holder, right? So the joint account holder goes in and take the money, even after the person died. And that's something I say you can do, right? Because joint accounts, they have the right to do that. Even after one party passes away, before the bank is aware of it, the account is not frozen, you can go and take the money. So the problem is this: if the joint account holder takes the money away, and then the will beneficiary says, hey, this money is supposed to be mine, but the money already belongs to that, is in that person's account. The only recourse the person has is to. So the question I will ask my client, right, if they say that to me and says, are you okay to sue before you get your money, for the beneficiary to get the money? If you're okay, then sure, just do joint account and then write your will. Of course, nobody wants that, right? The point is, again, what I said, right? If you have a joint account, the understanding is the joint account holder can take. If you want to contradict that, sometimes it takes a court case. Costs money. So if you have, in the case covered in class, there were 6 joint accounts, $4.5 million. I think $4.5 million worth suing. If you got 50,000, sue or not? By the time you sue, pay off the court fees, oh, you're negative. Pay 60,000 in fees, get $50,000 back. Right? So what? Lose $50,000? Potentially, right? That could happen. So that's the point about joint accounts, right? So for me, as I said, this part I just highlight the risk to the client and then just move on. I leave it up to them to decide what they want to do. Okay, so let's move on to the rest. Now, the rest of this part here is to go through a couple of different scenarios. I wanted to kind of put that list of considerations beside each asset class and then get you all to think through that. Unfortunately, I didn't have time to prep that. So we'll just do it. Hopefully you can, if you have taken a picture of that, maybe I'll just jump back very quickly to that slide again. You can snap a picture of this and keep it on your phone devices. And then as we are talking through each asset, you'll just go through this consideration. What is the best way to deal with it, right? So just snap a picture of that. And these are things to keep in mind when the client has that particular asset, then we think about what's the best way to give. Okay? No, you still need it? Okay. So easier for you to refer. Okay, everybody good? Okay, so real estate is usually one of the problematic assets, right? It's problematic because it can be distributed, it's valuable, there is potential liability on it, and all that complicates the problem, right? There are many different forms of property. So when you think about property, things we need to find out will be, we need to find out the ownership first, right? What form of ownership it is, right? Typically, people will have a house. If it's a husband and wife, a common scenario is that they will own the property jointly. And even for joint tenancy type property, we still want to plan for it because it's problematic, right? In this case, when we're planning for a joint ownership property, we are planning from it from a contingency perspective, right? Remember, that's one of the criteria for an effective will. What's the contingency? Contingency is common disaster. In the event husband and wife pass away, the last person to die would be sole owner of that property, right? And if that property isn't dealt with in a specific gift, it falls into your residuary estate and potentially goes to a bunch of people, right? And that's problematic, right? Problematic because giving multiple properties, giving properties to a bunch of people is difficult because if each of them have the different views on how they want to handle that, they can conflict and fight over it. And if each of them have the same share, then sometimes the only recourse is against suing, and the lawyers are the ones that are happy. Okay. If your property is tenancy in common, then you can give it away. It's part of your estate. You can will it away. It doesn't bypass your will. Right. But the same problem applies, right? If it's tenancy in common means own it in shares with other people already. And if you don't deliberately plan for it and you just give it to, again, a bunch of people through your residuary estate or otherwise, then you get even more owners, which complicates the problem even more, right? So even if you own TIC properties, you really want to think about it. What's the best way to handle that? Okay. Next thing to consider is outstanding loan, right? Many people would have an outstanding loan. Some people's house are fully paid for, great, lesser problems. But if you have an outstanding loan, then you may not be able to retitle the property to your new beneficiaries, because if the beneficiaries don't have the income level to sustain the size of loan, right? Especially if, let's say, a beneficiary is unemployed right now, right? Their child maybe still studying, adult already, above 21, but not working, no income. They may not have the ability to take on the size of the loan. And as a result, the only option is a forced sale. So they don't inherit either. Okay? And that's also another opportunity for you to upsell your insurance, right? If they never thought about it, sell them an MRTA, a level term or whatever, that makes sense. I don't know if they will be more willing, but end of the day, you may incur some still late charges if you decide not to pay. It could still be from family members where they will act to gather some funds to maintain that, to continue repaying the loan first, and then later claim back from the estate subsequently. Potentially, yeah. If you want to avoid the late charges and stuff, I mean, it's possible that you can negotiate with the bank eventually to say, hey, this guy passed away. Sometimes they can be flexible to waive some of the late charges. They can wait, but I guess how long they wait depends on the bank and stuff like that, size of the loan and risk and all that kind of stuff. So it'll be a risk assessment on the bank side of it, but they will definitely charge you. Yeah. So minimally, if they don't incur any late fees, at least you still have your interest charges, which is compounded more significantly because you didn't pay that monthly installment, right? Okay. Next. Yeah. If they are responsible for dealing with it. I mean, whether he comes with his own money, pull funds from other beneficiaries or family members, he's responsible. Yeah. So if he, for example, doesn't know and doesn't know how to prioritize the different debts to settle first, then you can incur more unnecessary charges. You know what I'm saying? Okay. So other thing to consider is ownership, right? And this is part of the, can the beneficiaries benefit, right? If you look back at that whole list. So if I give the property, can the beneficiaries own or not? So depending again on the nature of the property, if it's HDB, then HDB has a whole bunch of restrictions related to that. And so it can be a lot more problematic to give away. If it's private, it's a little bit easier. But if the beneficiaries have HDB, then it also complicates the problem. So whenever there's HDB in the equation, it's a nightmare to handle. Right? So we'll see some examples. We'll see a bit more criteria, I think, in the following slides. Okay. So one thing you can do with property is sometimes perhaps the only safest thing you can do is simply sell, right? Now that's usually what most people don't want to do, right? Everybody knows that people get rich by buying property in Singapore. And so they want to keep the property, enjoy the capital appreciation, but that causes all the other issues, right? If they want to own it, the question is who owns it, who owns what share, can they agree on what to do with it? But the safe thing that we can do in a will is typically sell. And that may be the only outcome for HDB in particular, right? If HDB is typically for staying, if your beneficiaries cannot stay, let's say they have minor kids, if they can't stay because they're staying in the guardian, you typically cannot hold it for them. So you have to sell. So if you already know upfront, then perhaps writing it to sell makes the most sense. Okay? You may not be able to. HDB cannot be held in trust without HDB's permission, right? And HDB typically will not give you that permission upfront, right? The principle that they abide by is that HDB is for staying, it's not for investment, and one person can only benefit from one HDB. So if you hold it, if your objective is to hold it in trust for the kids, right? The problem is you're still alive right now. You haven't died. So when you die, you don't know whether HDB will not know at the point in time when you die whether the kids have a beneficial interest in other HDB properties or not. So they can't give you a blanket cover to say, yes, they allow you to have it held in trust. Okay. Plus, if the kids are young, technically they will not be staying there on their own, right? You mean your kids are 9 and 11 years old, right? Can they stay in a HDB flat by themselves? No, they will likely be staying with the guardian, right? And so if they stay in the guardian, they can't stay in the flat, then you typically can't hold the flat. HDB will tell you, please sell within, I give you 6 months, please sell it off.
So of course, sell is one option. So if the client said no, I got to sell. So second option, is it possible that when you take over, we say you put a will to say when you take over, you have to sell this property and distribute the money. So once before that, sell, one is at death, then you give instruction the will to say that sell. The third option is all into a standby trust. Then from there, use a standby trust to pay out the benefit, but ownership is handled by the.
Sure. So for private property, the third option is available. HDB, you can write it in a will. The problem is there's no guarantees it will happen. So is the client willing to pay for 3 clauses, jump you up to the next pricing tier, and then no guarantees it will happen. So yeah. So if you think about it, property, there's only 3 options, right? You give, you sell, or you put in a trust, right? HDB cannot put in trust, so you only have give and sell. If you give, the problem, as I said, is a whole bunch of people own, they all fight. Then there's eligibility criteria. Give, can they own or not, right? Private property, you need to be at least 21 years and above, right? No other restriction, but HDB, whole bunch of restrictions, right? You must be, I think I have do I have it here somewhere? I think I do. Oh, I don't have it. I think it's in the another deck I had. So these are the only options, right? You basically have these three: trust, give, or sell, right? And so you just discuss with the client what are the pros and cons of each. Yes. So that's one of the strategies for the give, right? Instead of giving to a bunch of people, you give to one. And then estate equalization is another way that you can give other valuable assets, or if you don't have, create a new asset of equal value to give to them. And that new asset is typically insurance, right? Use that to create some funds of equal value and estate equalize, right? So one party gets a property, the other party gets something of equivalent value. Right? Other remaining assets, residuary assets, or newly created asset in the form of insurance. Okay, so that's another strategy. To me, I still classify that under the give, just that you give in a different way. Right? That's another opportunity for you to upsell your insurance business. Right? You uncover this need because it was not apparent before, but now it's there. That's another strategy you can use. Okay.
Children are adult 21, 5, they're capable of living alone, they're capable of themselves, but they're not allowed to own money. They're not married, for example. So they're not eligible, but they're actually capable of living.
Yes. Yes. So what we want to think about this is there's these two stages, right? What we're talking about is the planning. That means it hasn't happened yet. The problem with HDB is the planning part becomes very, very difficult. There's a lot of things we know may not happen. So if we write it that way in a will, which you can, and the client will have to pay for it, we don't know whether it will be executed that way, and that's the problem, right? So what you're highlighting is perhaps the second stage, right? I can draft it. I think the chances of that happening is a lot higher, and I think I've heard of cases where it has happened that way. So they're already adult, but they don't fully qualify, right? Maybe in order for a 21-year-old to own a flat, it must be in a family unit, right? So this family unit, typically you need to be married, but if a bunch of siblings might be possible, right? So it may be possible. So the first part is the planning. So the planning part is difficult. But on the other hand, HDB is also not heartless. They're quite accommodating, right? But for them to accommodate, they must know the facts of the case, right? And so if your client has already passed away and you want to appeal to HDB to have it held in trust for the kids or whatever scenario, you can do it after the death, right? You can draft in a will, but the uncertainty is going to be there. The client needs to be aware of that. But if the client has already died, one of the approaches is always, if you still want to have it held in trust, approach HDB. Get them, do the assessment, let them figure out whether can or cannot. Then they'll tell you can or cannot. Then if can, then great. You get it held in trust for the kids. If cannot, then cannot. Then I have to sell. So there's these two stages, right? The planning, not risky to say, let's do it this way, held in trust. But if you already die, please ask. You got no loss. Just ask. Okay. Yep. Okay. So in terms of planning for property, as I said, it's problematic. I guess when you think about property, the starting point is always what kind of property is it, right? Is it HDB or everything else, basically, right? Everything else could be residential, private residential, or commercial, industrial, or just land. Then there's another dimension, which is overseas or local. All this can affect what we're trying to plan for and how to deal with it. So these are some of the things to keep in mind. The safest thing we can do is, as I said, sell. Sell is very easy. Sell once you got cash, can distribute easily, but may not always be ideal, right? Okay, next other problematic asset will be business. Now this is another whole topic. Small advertisement. I'm running a buy-sell class from Precepts, supposed to run in March, I hope. It's not an ideal class to start off, frankly, in my opinion, but it is what it is. But we want to take one step back. Sorry? we do a business succession planning class. That solution is a buy-sell. You already decided on a solution. I want to sell, right? But the ideal solution is you take one step back is, maybe I want to give. How do I prep the business for succession with my children? Who are the other possibilities? So there are other options, right? And final option is to wind up. So you have give, sell, and wind up. So the discussion you have with the clients, if they have a business, in this case, we're talking about more of a privately held business. And this can be a very wide range, right? It could be a $500,000 business, or it could be a $500 million business, still privately held, right? Obviously, the outcome will be a bit different, but the options you have are still somewhat similar. It's basically give, sell, or wind up, right? So if you want to give, then the question is there anybody willing to take over, right? And that's the give part. If you want to give to your beneficiaries, do they even want the business, right? If you recall the crocodile farm case, Tan Nga Chua, in that situation, none of his 6 kids from his first marriage is taking over the business, right? Because it's probably not a very glamorous business to look after crocodiles. They have professional jobs, chances are. And so it was the illegitimate or the son given legitimation from the mistress that eventually took over the business, right? So finding a successor will be quite difficult. It's not today I want to give to my kid and then my kid will know what to do with the business, right? There's a lot of education and grooming that may be required. And so the earlier you have this kind of estate business succession discussions with your clients, the more runway your client has to think about, or the more options they have, right? The gift will be an example, right? It allows me to think about these issues if I never really thought about it. I may want to educate my kids to say, hey, maybe one of you want to take over the business. Should one take over, 2 take over, none take over? Should I have it professionally managed or whatever else? There are many different possibilities. So having the discussion early gives you the maximum range of possibilities, right? By the time the guy died, a lot of options are ruled out, right? To try and raise a successor at that point in time, probably not a good idea. Okay, if there are other business owners, right, it's not just the main guy who owns the majority share. There are other business owners. They have an impact on the business as well, right? Because they may not be willing to sell out the shares to a silent shareholder and not play the active role, because many of these the business owners themselves, the shareholders, are actively involved with the business, right? They are the founders of the business, they're running it. And so if one party exits because they died, or other trigger events, they are mentally incapacitated, they want to retire, they run a divorce, they get sued or whatever else, all these events can trigger problems with the business. So if not planned for, it can cause issues, right? So for the business owner, the buy-sell will go through the different strategies of handling the buy-sell. You can do the normal cross-purchase, you can do a buy-sell trust, you can do an entity purchase style strategy to exit the business, right? So again, it's a big topic. There's not enough time to go through this, but if they have a business, then those are the things to consider, right? So that's for the give. Then if you want to sell, then the question is sell to who, right? If you are the sole owner of the business, then maybe selling it to somebody else makes sense. You could sell perhaps to a competitor. You could perhaps sell to your employees, right? And then you got to think about sell at what price? How do you value the business, right? Private businesses are notoriously hard to value, right? The business owner would have placed a high value on it because he understands everything, but the guy from the outside cannot see anything inside, and so his value will be very low. Trying to get them to match can be difficult, right? So what formula do you use to value the business? You get a professional valuer in to value the business. There are all these dimensions that can make the sell part sometimes not so easy to execute, right? And to add another complexity, if you only own part of the business, right? Who are you going to sell your business to? You own 1/3 of the business with 2 other parties. Sell to who, right? Natural choice, maybe sell to the rest, right? And once again, the valuation agreement can be difficult. So these are some of the practical problems. But again, the key point I want to highlight at this point is that if you own a business, if your client owns a business, having this discussion earlier is always better than later, right? In fact, to make this a bit more personal, many of you are in the financial advisory space, right? You are business owners. If you were to check out our live today, what's going to happen to your business? Will your family be able to benefit from it? And what's your succession plan for your business? Hopefully, it's not the default wind up. right? That's like the, oh yeah, no choice already. Close it down. Nobody else can take over, right? Can we plan for that? Now, some of you may have that option, right? It's probably good for you to very check with your firm what is the exit strategy for your, right? Some of your firms will have a policy. If you have been running, you run your business for a certain number of years, some of them will buy out your business and then hand it off to somebody else. Some of them allows you to appoint a successor. Some of them, you can work out some kind of buy-sell arrangement among other advisors that you have. So these are some practical things to keep in mind, right? So if you've not done that before, think about that and plan for yourselves. Okay, next problematic assets will be your collection. So if you own watch collection, stamp collection, wine collection, sorry? Gifts, oh, sorry. Oh, sorry. Okay, thanks for that. Let me just quickly fix it before I forget again. FTS. The one before also? Before is okay. Oh, yeah. Okay. So some of these items are not so easy to give, right? Again, if you just don't deal with it and it falls into your residuary estate, trying to give a set of jewelry, 50 to spouse, 25 to son, 25 to daughter can be problematic, right? So the story here is of Robin Williams. Some of you may have heard me share about this before. So for Robin Williams, he died simply because he was suffering from depression for a very long time. And at one point in time, he couldn't take it anymore. He literally killed himself. So that's how he died, right? But for him, he actually did proper financial plans. So he did set up proper financial plans for how to distribute his assets, his financial assets, which were obviously sizable, to various beneficiaries, right? Kids from his previous marriage, by his final spouse and stuff like that. So it was planned out properly, the financial aspects. But he did not consider one part, right? Which is some of the stuff that he had was sentimental value. So over the years, he obviously accumulated lots of memorabilia, right? All his costumes and different things for all the different acting roles that he had. And it was all in his house. And the house was given to his then spouse, right? But he had, I don't know how many marriages, 2 or 3, I think. And he had kids from those previous marriages. And those kids wanted to remember him by, and so they wanted some of those memorabilia. The wife said, no, this house belongs to me. Everything inside belongs to me. So they almost went to court to sue over it. And these kind of collections, because they have sentimental value, there are a lot of emotional attachment to these kinds of assets, they sometimes defy logic, right? It's not about this is the right thing to do, or it's not about the value, it's really emotions, and that can be very difficult to resolve, right? So if your clients have some of these kind of assets, right, family heirlooms and things like that, it warrants some considerations, and that's where doing a specific gift of these items to certain groups of people who may value it a little bit more, right, might make sense, right? This could also be in the form of some kind of estate equalization, right? If I'm going to give this family heirloom to this, there's only one heirloom, right, or 1 or 2 items, I need to give to that one party. What else am I going to give to the rest, right? So that can also affect the emotional and family dynamics if one party or one group of beneficiary receives that valuable item or is recognized for that, but the others don't, right? That can also cause problems. So collections yeah, so that's one way to do that. In fact, we teach that again in the onboarding class, where we use the word as per label. So for these items, you have jewelry in a safe deposit box, right? So your beneficiary will be listed as per label. That means when testator passes away, the executor goes to the safe deposit box, opens it up. Hopefully your client has labeled all those items inside there into boxes or Ziploc bags or envelopes or whatever with the labels of the beneficiary name. And so you just take that bag and give to the person. Right? This is useful because it's sometimes very hard to refer to individual items, right? The gold chain with the dolphin pendant or the earring with the small diamond, not so small, but the larger one. It becomes very hard to refer to all these very specific items, right? So package up. Yeah, even you want to itemize it, you can take pictures, but now I guess you can, same thing, right? If you take pictures and then say these items go to that one party, it's kind of like labeling it, same concept, right? The difference is that document is not part of your will, so it's not legally binding. Yeah. So, or how do I know that's the correct one? I produce another one that says give differently, then who's the correct one? So that's the reason. So label it accordingly. Okay. Other practical things for this kind of these collections is lifetime gift, right? We said that earlier, one of the forms of distribution. If I have some jewelry, I wear them, I keep those for me, and then there's less of it to deal with it. Other jewelry that I don't really use, maybe give it away right now while I'm alive, right? So these are some things to possible ways of distributing. Okay. Another class of assets that are problematic, if again you have these, then it warrants you to consider that. You have overseas assets, right? Stocks and shares, real estate, businesses, insurance products from overseas, then there could be different laws that apply to them, depending on the type of asset, right? If you have real estate overseas, then law of the land applies. Wherever that property resides, that country's distribution laws determine how it can or cannot be distributed. So if you own property in civil law jurisdictions, right, then your will in Singapore may not effectively deal with it if it contradicts that country's law. Okay. Next, complexity of probate. So if you just, is there a question? Again. Where again? Complexity.
Gifts.
Oh, gifts again. Yeah, copy and paste. Thank you. Okay. Next slide, so I realize. Okay, I'll fix it later. So complexity of probate here, I'm referring to if you use a Singapore will, you may not, it can be very complicated to deal with overseas assets. So sometimes a better approach would be for you to consider drafting a will for that country's asset to deal with it, right? In this case, when if you're doing something like that for the client or for yourself, then you want to make sure that we scope the will accurately. What's the jurisdiction of that will? Is it meant to only cover a single asset, and we draft it accordingly, right? If it's to deal only with Malaysia assets, then we draft it so that we don't accidentally overwrite the other wills, right? So when you're thinking about this, consider which is the primary will, which is the will for only a specific country, and draft it accordingly. Okay. And if it's overseas assets, then sometimes it may be difficult for your family members to uncover them because they're not in the same country, right? If there's no proper documentation, you don't list down inside your asset listing, then it'd be difficult for them to discover, and you may just lose it, right? So that's important to keep in mind. Okay. Next, investments. Again, investments, because it's a bit more complicated to deal with. Same thing, if you do have investments, and I think many people do for their retirement portfolio, then you got to again consider can the beneficiaries actually own it, right? Do they have the skill to do that? Do you want to have it professionally managed or given to them, or liquidate and give cash? Yeah.
Currently, when someone passes away, certain broker, they can actually create like a estate account so that you can straight away move the stocks, right, to the estate account. Then there's some others broker, basically you have to liquidate it first, then you gotta buy, then you probably buy at another price. Are you aware about this?
Yeah. So in Singapore, if they are the Singapore brokers, then it's probably the first case, right? The executor/administrator will be the one who will set up the estate admin account. Then they need to apply with the grant of probate letters administration. They will apply to, depending on what asset, right? If it's CDP, then you write to CDP. It's possible to transfer these assets to the estate account and then deal with it from there, right? Either sell or whatever. No need to liquidate. Now, that's for Singapore side, right? But many people own assets overseas. Now, then exactly what policies they have may vary, right? If you own it with IBKR or SwimTrade or Charles Schwab or whatever else, other international brokers, how they practice, their documentation requirements may vary. And so you need to verify what are the processes in advance, right? And then prep your executor/administrator to deal with it. Okay. Now, another dimension of this is the tax part again, right? Again, nowadays it's quite common for clients to own overseas assets. And so there's this view that if I own this US stocks and shares in a particular way, using this particular broker or that other broker, I can avoid US estate duties. Okay. So the reason, according to some tax advisors, right, from the US themselves, it's basically a myth. The reason why some people avoid it is because of lax enforcement, right? The way it's supposed to work is before, if your family members, your surviving family members or the executor goes and claim those estate, by right, they need to produce a document, a tax document that's to indicate that they've already discharged all tax liabilities before the assets are released to the family members, right, or to the executor. Now, this part of enforcement has been lax. Now, I think because US is in massive debt and they're all trying to find all different ways to make sure that people pay their fair dues to the US tax authorities, this is getting stricter. And so all these brokerages that try to avoid this, they risk losing their license. So they are going to be stricter in enforcement, so it's going to be harder to avoid this issue. So the bottom line is, the understanding is that if you manage to get away, good luck, you're fortunate, right? But the standard answer is that you have to pay estate duties. You can't run away. Of course, another strategy that some clients use is this, right? Which is, when I die, my wife have my account locked in, go and sell, and then move the money out. Okay? So then you ask the client, oh, you're okay to do illegal things, is it? When your husband or wife die? Because it is illegal. Now, we cannot obviously condone such things, and so if they want to do illegal things, then subjected to them, I mean, up to them. It's just user ID and password. It's quite easy to log in. It's quite easy to execute. The question is, if they ever get found out, it's a problem, right? They are cheating the US side. I don't know what kind of enforcement or whatever that will be there, but as I said, they're doing something illegal. If they're okay doing that, then well, cannot say too much. Right? It's not my money, not my beneficiaries. But at least they now know it's illegal. Okay. Okay, so in summary for specific gifts, right, as I explained, the idea of specific gift here is that we look at the different assets and try to identify problems, right? Because it's problem in the sense that if we don't deal with it, it goes to the residuary beneficiaries, to a bunch of people, and it may not benefit the beneficiaries. It causes unnecessary tax burden, or there's leakages. It causes problems among the beneficiaries. So we're trying to avoid that. And so once we know the residuary beneficiaries, you look at the asset list that the client has, right? And all of you should be looking at your own asset list, whether you have those problematic assets. Think about how you want to do it. How do you want to distribute it? I had a list of different ways, right? You can do lifetime gift, give in a will, through residuary, gift through a specific gift, give to a testamentary trust or living trust. Which of these makes the most sense, right? How much of it do you want to legally enforce your intention? What are the transaction costs involved with that? And the whole list of criteria. Think through that on your own assets and then draft your will accordingly, right? So your job as a estate planner is to guide your clients through the same process. This is a non-exhaustive list of the problematic assets. So that's a good starting point for you. If your client has those things, right, they probably have property. So definitely you got something to talk about. And that's how, again, you value add to your clients. Okay. Now the last part is, you've got about 15 minutes more and we're going to move to the testamentary trust. I think we should be able to finish. So in the earlier two forms of gift, it's always lump sum and immediate upon death, right? And if you think about it, sometimes that may not be ideal. In fact, most clients probably want some kind of control over their assets when they die, right? The question is only, are they willing to pay for it? Sometimes some clients are not, right? And so they do it the cheap way, or the illegal way, or the hopefully things work out way, right? The hopium way, right? I give to my son, hopefully he will take care of everything properly. So we need to help them recognize that these are their potential issues. If they're willing to accept it, then as I said, it's an informed decision, so be it. Then maybe next time we will see all their names inside our case study research training next time. Okay, so these are some of the problems to highlight, right? We have these three situations of this family losing the monies paid up from insurance and donations. We got this guy who's involved with illegal matters and drug charges. We've got this kid here, 22-year-old guy who drive and got into a serious accident. So what's common between all these stories is that certain gifts were made to them without considering the effects it may have on them, right? And so in the first case, if I control the gift, right? In fact, this was actually the conversation that Changi Airport Group had with NVCP, National Voluntary and Charitable something. It was an organization that helps with charity work. So they were advising Changi Airport Group when they receive all these donations to not give directly to the family, but set up a trust for them. Changi Airport Group took the easy way out and gave it to them. And they lost $2.4 million in 1 year, not 1 million. Reported 1 million, but it's actually $2.4 million. Okay. This other guy, there were 1 or 2 cases about that. Basically, these are, I think this is a Metro Scion, right? Yeah, the Metro guy. So again, too much money, too much time. And as they say, right, idle mind is the workshop of the devil. So he got involved with all kinds of illegal stuff, with drugs and stuff, and got caught. Okay. So end of the day, when we think about this gift, for many people, they want some kind of control over the assets. And so we use a trust to handle that, right? And for me, the planning usually starts off with, let's start off with the most cost-effective form of trust we have, which is the testamentary trust. Do it within the will. As you're engaging the clients to draft out the wills, we also add in the trust, right? So if you look at the TD forms, inside of the document that you have, the worksheet, these are the broad 6 things that we're trying to do within the testamentary trust, right? Now, if you look at some of the EWF, there's like so many questions inside there. Hopefully this helps you visualize the process of what we're trying to do. It's not exactly in the same order that you will see, but these are some of the things to do, right? First, we want to think about a trustee. Who is the main person that will handle this? By default, your trustee is the executor, right? And for some people, that may be fine, but in other situations, the executor may be okay to distribute your stuff, but now ask him to look after your assets for your kids for the next 20 years. No, I'm not comfortable to do that, right? So who you want to pick as a trustee matters. Think about it in terms of accountability. Think in terms of whoever you pick, if they don't track the monies in and out over time, will the money, the inheritance still be there by the time your beneficiaries supposed to receive what they're supposed to receive, right? That may not be the case. So who you pick as trustee is important. Okay, the next part here is to decide what assets to be included. Okay, in a typical case, if you have children, then your children would receive part of the residuary estate. We will then route the residuary estate, instead of giving directly to them through an implicit trust, we route it to a testamentary trust, right? So in the asset listing, we simply say children's share of the residuary estate. Okay, this allows us to, we don't have to itemize specific items. Now, if I set up a trust, it could also be around a specific item, right? You could sell a particular policy, 2 million payout policy, and the whole trust is structured around this gift. So that's possible. In this case, we name that policy directly in the asset listing, right, for the setup of the trust. But for most people, it's going to be whatever they have for that part of the residuary estate. So we just refer to it as the residuary estate, or the share of the residuary estate for that group of beneficiaries. Okay, then choose your beneficiaries. Depending on who you're giving to, it could be kids, it could be elderly, parents, or a combination of both. If you want to set up a simple form of trust, it can also be a charity where you give over time instead of giving as a lump sum. So your, I don't know, your name will appear in the donor list for many years or something like that, right? And you'll be remembered better. So think about who your beneficiaries are, right? And as usual, whenever we think about beneficiaries, we think about substitutes, right? Now, when it comes to this kind of trust, sometimes there may not be substitutes, right? And it's okay in this situation, right? For example, I'm providing for my kids. this trust is for my kids. If my kids have already passed on or they've already grown up, then there's no need for the trust anymore. And so I may not need to have any life interest substitute beneficiaries, right? And that's okay. Because as you will see later, at the end of the trust, when the trust ends, and the trust will end because the terminating condition was hit or all the beneficiaries died, then you deal with the substitutes at that final stage. Okay. So next, we determine the duration of the trust. How long do we want this trust to last? Okay. So in the form itself, you can see that there are different ways of handling that. We can say until a beneficiary reaches a certain age, or until certain events happen, or whichever happens first, a combination of all these things, right? X number of years after my death, or when my children get married and move out of the house, something like that. So you can specify them. But what's the maximum duration of a trust in Singapore? 100 years, right? So implicitly, there's always this limit there, so that the trust eventually will end, okay? And that's by law. Okay, next, determine your distribution condition. So if you look at the form, the actual EWF, there's a couple of variants of this, right? There are 3 parts, if I remember correctly. The first part talks about, is that the form here? Let me just see, yeah. This immovable. Okay, for my templates, I don't split between movable and immovable because I'm just trying to keep things simple. I just want to understand the intent. Over here, it's slightly more complicated. It's actually almost like the EWF itself, which I'm trying to avoid. Okay, yeah. Okay, so this distribution part is, I think, 6.2, page 6.2, the middle part there, right? Distribution of trust assets during the trust. So there are a couple of things we can think about. We can say, do you want to give a lump sum gift or a periodic gift, right? X amount of dollars a year. And so that gives a bit more clarity to the beneficiaries in terms of what they get. But then there could also be one-off distributions. There could also be certain conditions. So we can specify all that under the paragraph and then decide how much we want to give. Okay. And in a simple form, we can simply say, leave it to the trustee to decide. Don't give any fixed amount, right? And sometimes that might be actually easier and maybe perhaps more effective, again, subjected to who your trustee is. Okay? If your trustee, for example, is your spouse, who is also the trustee for the trust for the kids, then that may not be such a big problem, right? End of the day, the money is held by the trustee, used for the kids. The mom decides how much to give, when to give, probably not an issue, right? So sometimes we may not need to. It's okay to keep it simple and just simply say discretionary share, no fixed distributions, let the trustee decide. Okay. Obviously, whether you do that, whether that makes sense or not, depends on what's the purpose of the trust, who the beneficiaries are, and so that consideration has to be there to see whether that makes sense. Okay. Okay, and then the last part to consider will be at the end of the trust, right? So while your trust runs, all the distribution happens according to that earlier section. Then at the end of the trust, what do you want to do with it, right? So that's something we need to ask our client as well. If there's any remaining assets, do we give it to the beneficiary, right? Because the beneficiary could exit the trust. Maybe the trust runs until they're 35 years old. Then at 35, they can receive, they're deemed to be old enough to receive whatever remaining assets. So we give it to them. So that's one possibility. This is where we want to think about the substitutes in this case, right? Because one of the ways the trust can end is also if the beneficiaries die, right? If I'm giving to just my only son and my son died in a car accident or whatever, then the trust will end. So giving to him may not make sense. I may want to give to substitutes instead, right? And then substitutes could be the residuary beneficiaries, or I could name a charity. These are strategies that you can pose to the client and get them to think about it. Okay. All right, I think we're pretty much coming to an end. Okay, the form here again has two variants, right? For me, when I do planning, I don't split between movable, immovable. I try to keep things a little bit simpler, but the detailed form is over here. You can refer to all those details. If you have a property, you may want to consider it, especially if it's a private property, you can have it held in trust. Okay? There are 3 different forms of trust, which I think is stated there: standard trust, trust for sale, trust for life tenant. But I think everybody is a little bit tired, so let's not go into all those details over here. So this is really just the starting point of estate planning, right? When we do the will, it's really the starting point of the estate planning conversations, but there's usually potentially a lot more things. One of the things I cover in some of the other trainings in terms of positioning is that we want to tell our clients that we don't just do estate planning, but we also do financial advisory, we do investment management and stuff like that. So our positioning, and in terms of the scope of estate planning, we don't just do wills, right, of distributing. There are other aspects to consider. For example, there is digital estate planning, right? So all of us will have tons of emails, social media accounts, we may have cryptocurrencies, we may run some website somewhere, we may have KrisFlyer miles, Capital Star points, and all these stuff. Collectively, we call them digital assets, right? And if we die, what happens to them, right? Planning for that is quite critical because many of us, we definitely have all these things, right? We live our lives online very much as in the real world. And many of these things are valuable. In fact, a lot of our financial statements and everything are all digitally to our email right now. If we die, does our family member have access to all these things? Right? How can I give them access only when I'm dead and not when I'm alive? Right? So that's part of the equation. Things to consider for digital estate planning. Right? The other part is the risk issue. If I pass away without dealing with some of these things and I'm not around to look after my accounts, people could compromise my account because they guess my password. If they access my account, imagine any of you use Facebook accounts? Right. Do you use your Facebook account to log into other sites? Do you use your Google account to log into other sites? If you do, if your Google account is compromised, they have access to everything else. And suddenly your family members may have to deal with, oh, this guy applied for some loan somewhere using some account or set up some email to scam some other people. And then your reputation, and you're already dead, gets tarnished by all these kind of things that happen, right? So it's a nightmare to deal with after you're already dead. Okay, so that's digital estate. Then, of course, there's trust, wills, LPAs, and stuff. Again, the positioning is that because with all these other stuff, there's a lot more scope to revisit the client, come back again, talk about other areas. But this positioning should be done right at the start of the conversation before you start engaging the client. Okay. So with that, I think that's about all I have. I guess everybody's tired. So any final questions before we wrap up, or maybe Annabelle has?
Such a workshop, for the what you had in today's session, he can rattle off everything, anything, any objection, he can give you objection handler. And then sometimes he'll be able to tell you stories of what happened previously and why you shouldn't do that. So I think eventually as we gain more case studies, newspaper articles on what's happening, then we can use those stories to share with your clients. So what you see on Twinkl, we actually have some of the newspaper articles that we talk about in the 3-day class, but you can actually use those case studies to play. It's all done up in a nice format already, so you could use those. What we're trying to do is you really have this framework, right? So typically when you meet the client for the first time, we'll encourage you to use this first because they need to understand when they die what happens, right? So this is the simplified way to explain estate planning to them. And then when they are ready to move on to the next step, where they say, okay, I want to do a will, then that's where this worksheet comes in. You can see that this is still a work in progress. That's why it's not in a finalized format like that. Once we are, get feedback from everybody, like John gave some feedback already, we will then look at printing it as a booklet like that. All right, so there's progression. When you meet a client for the first time, use this one. When a client is keen to proceed, then you use this one. Okay, so that's what we're trying to do.
So if it may add on to that point again, right? So the worksheet is actually quite critical. Because in class, some people always ask, should I have the EWIF in front of me to talk to the clients, right? The answer is no, it's too complicated. It makes it detracts from the whole planning, right? This purpose of this form is to simplify to the key ideas that you need to gather from the client. So it's the fact find part to figure that out. So it's meant to be simple. Right now, as I said, they did quite a very beautiful job, looks really professional, but I think a bit hard to use at this point in time. So it's first cut can be simplified further. So that's really the intent, right? To make it easier for you to talk, identify the key things, right? To me, things like identifying the name and the relationship of the beneficiaries are probably all I need. I don't need NRIC or address and that kind of stuff. I don't need it for that initial discussion when I'm trying to figure out the plan that the client has, right? So we're trying to come up with something to simplify that process a little bit more.
Call to action is exclusive to everyone in this room. In the next 3 months, within the next 3 months, as long as you submit a new case, so LE must be after today, okay, LE after today, and finalize within 3 months, the first 3 of you will receive this invitation voucher, basically to take a corporate photo. Okay?
Me also.
Branding and update your LinkedIn photo. I think it will be useful for everyone. Okay, so once you have that, submit LE, finalize the case, text marketing directly. Top, first 3, no, top, not top. So we're not looking at sales. So I'm not trying to get you all to do a lot within 3 months. I'm just doing basic.
Just do.
Yeah, just get started. I think that's the trust. No, either real or trust. If trust more, even better. Right? Good for you, good for your client. Okay, so as long as there's a product taken up, the first 3 to do that, let us know. We will give you this voucher. The vendor has a few outlets, of which one of them is just downstairs, level 1, opposite the near Watsons. Okay, so you just come in corporate where you can go downstairs and take. Okay, thank you.
Feedback, I will be sending it.
First run, trying to improve this further. Then as we subsequently run this, oh yeah, I want to give you an overview. This first run is for ESP. We'll do this every month. So next month, we will also run the same thing for ESP with other elements added to it. So just look out for a flyer, what's the difference. Then the third month, which is in March, we'll be running for clients. So this means that while you are learning on the third, once every quarter, so in this case, March, we will ask ESP invite client for the estate planning workshop. So you can come with your client and then you sit side by side. Then there will be times where John will pause. Okay, let's discuss who can be your executor. Then everybody discusses it. Okay, so that's the end goal. So we'll repeat this ESP client. And yes. Okay, so while you bring your client here, you really have an idea what is it gonna be, and then how you're gonna guide your client. Shorter, maybe 2 hours. Yeah. For client, not so long. And for client, right, the session will be either in the evening or Saturday morning. Yes. It's really an introduction. Yes. Yes, it is. So what we're trying to do, right, okay, is because some clients you can go very deep dive. Okay, but if not, this page is really sufficient to do an introduction. Okay, so basically this is ISA. If they die without a will, then what happens? Then is to really explain to them, when we die, we may assume that all our assets will go to our beneficiaries directly, but it's not true, right? Because there's always leakages and there's always delay. So if you don't take action now, then definitely going to be leakages and delay to the beneficiary. So how? Right? So that's really to tell them we need to take action now to prevent those two ones in yellow. Okay? So then I need to understand your family. So I need to know who are your beneficiaries. So that's where the family tree comes in. Then I need to know, do you have someone in mind who can be your executor and trustee? If you don't have, don't worry, we have the solution, corporate executor. Then I need to understand where are roughly your assets. We don't need to know so much first, but basically, are they all in Singapore or overseas? So it's a very quick overview. Then immovable or not. Then have you thought about how you want to gain? Then based on your family tree here, are there any beneficiaries are actually vulnerable? If there are, then you may want to consider periodic delay or conditional gifting, right? Because they may not be able to manage money so well. That's all. First meeting, done already. May not even need to go to the next stage. Because next stage, this is where the detailed planning is. Where you look at all the different tools available in the market. Not only a will, not only a trust, not only RPA, also CPM nomination, insurance nomination. So you may want to split it. Don't say so much in one at one go. Then this could be part of the explanation together with the detailed planning worksheet. Then the client don't feel so overwhelmed. Then if you go on a second appointment, positioning is really where we check whether they have enough funding. Because based on how much they want to give specific gift, how much they want to provide for their family, just take a calculator, total up. They might not even have enough now. If they don't have enough, how? That's where the funding comes. Or they need to sell a property, or what? Are they comfortable with that to provide that funding? Yeah, so this is really not a one session, unless client very interested or a lot of time with you. If not, take it in a few steps. Any more questions for us? Yes, Karen? Yes. Oh, this is in terms of okay, currently for standby trust, right? If you go to the website, there is one part that shows client or practitioner under one. There's a trust bundle. Click on the trust bundle. That is we have put the standby trust, will, custody all in one package at a standard price. Deposit 3,500. Yes. Later. That's under trust. Everyone.